I just pressed the Let's Go Live button. You know what that means. We got to wait for those tubes to fire up all across the fruited plain of America. Before we get into it, are we connected on? Yeah, it looks like, hey, locals fired up pretty quick today. Amazing. Rumble's coming in. We've got the Telegram fired up and our friends on YouTube. Amazing. That means we can go ahead and get started. So let's do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney. And today, we're talking about Trump moseying his way up to the Supreme Court of the United States. And we're pretty excited about this one. We're talking about the Colorado ballot removal situation. We know, and we've been covering this for some time, that Judge Sarah B. Wallace at the district court level in Colorado said the 14th Amendment does not apply. Then it went up to the Supreme Court of Colorado, and they reversed her. They said, nope, sorry, Trump, you are thrown off the ballot. And we've been waiting for Trump and his team to decide whether they were going to go to the Supreme Court or not. Of course, we speculated that they were, and now they're here. So they submit their petition to the Supreme Court. We've already here on this channel talked about another petition that came out from the Colorado GOP. And so a bunch of parties are involved in this. So the Colorado GOP already submitted theirs. Today, Trump is submitting his, and we're going to go through and see what is inside. Then we've got some reaction from some people in Colorado, including the Colorado lawyers who have been behind the ballot removal shenanigans. Also, Crazy Eyes Griswold is going to be joining us. And you can see here, she is going to say, you know, Americans deserve to know whether Trump's an insurrectionist. And she's one of the people who is at that meeting with the other secretaries of states. Then we've got former Trump attorneys responding to some of this, giving us some opinions on it. And then we'll wrap up that segment with Byron Donalds in the House. Then we're going to see what Jack Smith is up to. Well, we know he's up to a bunch of no good, always making problems in the neighborhood. And so we're going to hear what's happening because Donald Trump and his team have decided that they're going to ask for contempt, to hold him in contempt. And so that motion dropped today. They say, you know, this case is on appeal. Judge Chutkan, you said this case was on appeal. This is all going up to the D.C. Circuit Court of Appeals. And while we're there, it's supposed to be on hold. Why is Jack Smith continuing to file all this nonsense and deliver us disclosure? That's what it means when the case is held in abeyance. So we'll go through that. Jack Smith, who's illegitimate, by the way, not even legally appointed, saying that he should be held in contempt, which is absolutely true. Trump issued a campaign statement. Nancy Pelosi's out talking about January 6th being an assault on our personal freedom. You know, her. And then Karine. So Biden's out now saying we're just a couple days away from the insurrection anniversary, my friends. Happy anniversary. Third anniversary of the J6 end of America. And so Joe Biden released this new stupid video, and they're really good. Like, this is going to be their campaign for the next, however long. What have we got? 11 months now. Like, literally. We've got asking questions to Karine. Who is Joe Biden's scholarship team? Where is he getting all this insurrectionary language? And so we'll see what she says about that. Then we're going to turn our attention to our old friend Ray Epps. Oh, man. He got a 6-month sentencing recommendation. Oh, it's not funny, man, because there's a bunch of other people who did not get 6 months, okay? They've got a lot more time than that, talking about like 16 plus years for conduct that was a lot less serious than anything Ray Epps did. So we're going to talk through this one. We got a bunch of stuff pulled up. DOJ's memo coming in. They say, first of all, Ray Epps is definitely not a Fed, okay? Like, he never got a paycheck from us, and we checked our HR records, and it never said he was an employee here. We'll go through that. Ray Epps wrote a letter also to the judge. We'll see what the judge does, okay? The judge can give him, jail or not. We'll see. So Ray Epps also sent a letter. I'm under attack because of Tucker Carlson and so on. Okay. So we'll hear from that. And then we're going to say what's up to our friend FreeStateWill, William Pope. If you've not been following this fella over on the X platform, you really should. And he's doing great work. He's also been charged with crimes from the demented DOJ. And he's saying, if Ray Epps is getting 6 months, a sentencing recommendation, That's great. That's great news for me because my case is even less severe than Ray Epps. And so if he's getting 6 months, I'm looking forward to my 6-month deal and my recommendation from the DOJ. Do you think that FreeStateWill is going to get that same recommendation from the DOJ? We'll see. So he submitted a motion to dismiss his case for selective and vindictive prosecution. And so we'll read through that and send our love over there for Mr. Pope. So we're going to go through that, Ray Epps, his 6-month garbage deal, and so on in the 3 segments today. I'm grateful that you are here and with us, my friends. Thanks for joining us. For our members, we really try to deliver for our members. We did some member-only streams. We do member-only streams every morning. We already did a stream today. And we talked about the Biden Border Patrol. Okay, they are cutting the razor wire in Texas that's actually working. They are cutting it. And then now they're appealing that whole situation to the Supreme Court. Okay, because Texas got an order from the Court of Appeals saying, stop cutting the wire. And then now Biden is appealing that to say, we really want to cut the wire. So it's insanity. Okay, our own federal government is coming after the states for protecting their own borders when our federal government is causing an invasion to happen every single day. We also went through the Epstein files. We went through them. We actually analyzed what Technofog had put out, another great follow on the X, and he gave us a nice summary, like 900 plus pages. And so we just did some searches, some control Fs. We looked for Bill Clinton. We looked for Prince Andrew. We kind of poked around the document and we went through it. We're always interested in the Epstein stuff. We covered the entire criminal trial of Ghislaine Maxwell, read through a lot of transcripts and excerpts there. But we know that this is all part of a cover-up. And so we're just kind of not expecting much to come out from these things. But we did go through it, some interesting tidbits from Prince Andrews and Bill Clinton and so on. And so those segments will be out later. But if you're a member, you can join us live and get those early. And we love our members. We really try to deliver. We do members-only morning streams. We do Saturday streams. And it's a great community, really. It's really awesome people. We have a lot of fun. We're going to solve the national debt. We have a revolver fund. It's great. So come check us out, Watching the Watchers. For Teddy Roosevelt's revolver, $1.2 million, watchingthewatchers.locals.com is where you can come and join us. We also have our website, robertgovea.com. If you want to get any of the PDFs or access to the mind map, sign up for our daily newsletter. All the goodies are there, robertgovea.com. We really try to deliver reports for you. Hopefully, you're enjoying them, sharing them, and checking out the PDFs. All the red lines are uploaded there. And then, of course, our fitness project for this year and this month is still underway. So you can still join our 31-day fitness challenge. It's at watcherlodge.com, which is our newest project. We're really excited about this platform and getting some energy there, including improving our health and our wellness. And so we have this fitness challenge. It's a health challenge. If you want to do something good for yourself for 31 days, you have up until Friday tomorrow to join in on it. Then we're going to start to really dial in on the people who are committed to this. And the next 31 days, we're going to do weekly check-ins on Monday morning. We're going to have Monday morning motivations so that we can all just check in. And we got a lot of activity, man. People are doing all sorts of cool stuff. And it doesn't have to be like bench press, okay? It can be, helping yourself, doing something else healthy for yourself. So we also have prizes that we're going to be giving away, scholarships to the lodge, cash prizes, one in there. And so it's going to be fun. Watcherlodge.com is the place to go and check it out. Watcherlodge.com. And then, man, I've got some other really fun stuff queued up there. So we cannot wait to get this year going. Now, let's get into it, my friends. And jump right in to the Supreme Court. Trump goes to the Supreme Court of the United States. This one's on the Colorado ballot removal issue. We know that this is on appeal because what happened was at the first level, Sarah Wallace in Colorado said the 14th Amendment does not apply to Trump. Sorry. Yeah, there was an insurrection, but the removal clause in the Constitution just doesn't apply to him. And so she said he has to stay on the ballot. Then it went up to the Colorado Supreme Court, and those 4 Democrats, all appointed by Democrats, they reversed her and said, sorry, the 14th Amendment does apply to Donald Trump, and he's off the ballots pending higher court orders. And of course, that is where we're at now. The Supreme Court is the highest court of the land, the United States Supreme Court. And so Donald Trump has submitted that to them, asking them to hear this case. We'll see what they do. But as it stands now, the removal process is being stayed. So Trump will be on the ballot pending any other further decision from the court. Now, something could happen, and the Supreme Court could also say, we're not even going to take this case. How about denied? A petition for certiorari denied. And everything that stands currently stands indefinitely. In other words, the Supreme Court Colorado decision is going to stay. So we'll see. Now, I think the Supreme Court is going to accept this because this is kind of an insane thing that's happening where secretaries of state are disenfranchising their entire state from participating in a federal election. It's kind of nuts. But what else would you expect from Crazy Eyes Griswold? Jena, the one here we'll hear from in Colorado. So let's jump into this. We've got the Trump petition to the Supreme Court. Here's the filing. In the Supreme Court of the United States of America, Donald Trump versus the Anderson petitioners. These are the litigants who have been behind these efforts. And so Trump is petitioning here, and the Anderson litigants are responding. This is a petition for a writ of certiorari, and you know some of these people on this list. This woman in particular, shout out to Harmeet Dillon from the Dillon Law Group. We remember her. Doing great work here representing the former president. Here's the question. They say the Supreme Court of Colorado held that President Trump is disqualified from holding office of the presidency because he, quote, engaged in insurrection against the Constitution, and that he did so after taking an oath as a, quote, officer of the United States. Now, the state Supreme Court ruled that the Colorado Secretary of State should not list President Trump on the ballot and also disregard any write-in votes. Now, the state Supreme Court did stay its decision pending your review, SCOTUS. And so our question to you here today, from Donald Trump and his defense, in this case, his petitioner team, did the Colorado Supreme Court err in ordering President Trump to be excluded from the 2024 primary ballot? We'll get to it. So we know who the parties are, Donald Trump. We also know the Anderson litigants are these people here. Jena Griswold, Crazy Eyes. Colorado Republican GOP already submitted their petition to the Supreme Court, which we read here in a separate video. We forward ahead, past the table of contents, through the appendix, through the table of authorities, and on we go until we get to the petition. Trump's team writes, "It is a fundamental principle of our representative democracy that's embodied in the Constitution that the people should choose whom they please to govern them." That's us. Now, Trump, in this case, is the leading candidate for the Republican Party nomination for president. Over 74 million Americans voted for him in 2020, including more than 1.3 million voters in the state of Colorado alone. But on December 19, 2023, the wacko Supreme Court in Colorado, they ordered President Donald Trump removed from the ballot. That is a ruling that, if allowed to stand, will mark the first time in the history of this entire country that the judiciary has prevented voters from casting ballots for the leading major party presidential candidate. It's insane, obviously. Now, in our system of government of the people, by the people, and for the people, remember that? Colorado's ruling is not and cannot be correct. This court should grant cert to consider this question of paramount importance, summarily reverse the Colorado Supreme Court ruling, and return the right to vote for their candidate of choice to the voters. Now, the question of eligibility to serve as president of the United States, that's a question for Congress, not state courts, to consider and decide. By considering the question of President Trump's eligibility and barring him from the ballot, the Colorado Supreme Court arrogated Congress's authority. They usurped them. Now, in addition, even if the Colorado Supreme Court could consider the challenges to Trump's eligibility, which it cannot, but even if it could, it misapplied the law. First, here's why. Trump and the presidency is not, quote, an officer of the United States. He took a different oath than the one set forth in Section 3, and the presidency is not an office under the United States. Thus, the president, Donald Trump, falls outside of the scope of the law. Now, second, the Colorado Supreme Court also erred in how it described Trump's role in the events on J6. It was not insurrection, first of all, and President Trump was no way engaged in it. And third, the proceedings in Colorado and the Supreme Court were also premature, and they violated the Electors Clause. And finally, there are many other grounds for reversal, and as many scholars have pointed out, including 3 grounds for reversal presented in the petition for certiorari filed by the Colorado GOP, which we've read through here previously. Now we fast forward and we jump right into the statement. They say, over the last few months, Supreme Court of the United States, Trump says more than 60 lawsuits or administrative challenges have been filed seeking to keep Trump from appearing on the primary or the presidential ballots. The common theory behind these lawsuits and challenges, and who's funding those, right? 60 lawsuits? Where's all that money coming from? Lawyers don't work for free, man. So they want to get paid. Where is it coming from? Now, the common theory behind these lawsuits and the challenges is that President Trump is somehow disqualified from holding office under the 14th Amendment. Courts that are considering these claims, like Michigan and Minnesota, have already rejected them and acted contrary to what happened in Colorado. The court stayed its ruling in this case until January 4th, which is today, and announced that it would automatically continue if Trump sought review in this court, which they did today. The respondents in this case include 6 individuals eligible to vote, including Jena, Crazy Eyes, and they say that Section 3 establishes a constitutional limitation on who can run for president. The Anderson litigants, the people who want to remove Trump, are bringing this claim under the Colorado law, and they say that they are allowed to sue anyone charged with a duty who's about to commit a wrongful act. And they say the listing of a candidate on a ballot is a wrongful act. And they demanded, because they have a right to sue, that all of this gets cured within 5 days of the filing deadline, and they really went fast. But nothing in Colorado's law requires the secretary to evaluate these people. Instead, the Colorado statutes require a primary candidate to submit a notarized statement of intent. That form's on the website. All they got to do is affirm it. A signature line appears right here. It's it. Here's the statement of intent form. This is all that is needed. It says, I intend to run for office and I solemnly affirm I meet all the qualifications prescribed by law. That's it. A signature line appears there. Trump signs it. Donald Trump, right, with his cool signature. And Colorado law imposes no duty on the Secretary of State to verify and second guess the candidate's sworn representations. Now, the Anderson litigants, the people who want him removed, they insist that Secretary Griswold, Crazy Eyes, has a mandatory duty to enforce the Section 3 of the 14th Amendment. And they get this duty from the Secretary's oath to support the Constitution, right? So they're cobbling together this claim. So you got to do something crazy. Now, these also incorrectly claim that any decision to include Trump would be a breach or a neglect of duty. So if she doesn't remove him or consider this, she's in trouble. And so she, of course, acted. Now, the Anderson litigants filed their petition back on September 6th. The district court did not, however, hold a hearing within 5 days of the filing. So obviously they violated that right there, due process violation. But they scheduled it to begin on October, 54 days after the petition was filed. So it was dead on arrival. Now, the district court denied the motions to dismiss that Trump already filed, which he had already intervened in the case. And they're not complying with the law. They also denied Donald Trump's basic discovery tools, including the opportunity to depose experts or to provide potential witnesses or to compel the production of documents or to receive timely disclosures. You know, all of those basic things that we have in due process concepts in American law, gone. And they will tell us, well, there was a trial in Colorado. Why? Because stinky Eric Swalwell came? And the compressed time frame gave Trump only about 10 days to identify and disclose his rebuttal witnesses and 18 days to disclose his rebuttal experts. The district court then held a 5-day hearing. That was Sarah B. Wallace. We covered it all here. And the findings of fact, so the judge said, this is what I think is true, rely heavily on hearsay. It's all the January 6th report. Okay, they just incorporated it. She admitted it, even though Donald Trump said that's hearsay. Obviously, that's all not relevant here. Now, the district court also relied on testimony from this guy, Peter Simi, a professor from Chapman University. He came in. He's the Trump political extremist whisperer. Okay, Mr. TDS comes in and says, I know what these people are really talking about. Insurrecting America. He said, go peacefully. He literally said, go peacefully. That means execute everyone. Well, that's wild. So he says that Trump has a history with political extremists, and he developed, there it is, coded language based on doublespeak. It's incredible. So even if Trump says, go peacefully, we're going to march peacefully and patriotically, he's like, I guess that means murder everyone in Congress. So, you know, it's really difficult to communicate at all when they just say the things you say are murderous language. So the district court also relied on Simi's testimony saying that Trump was intending to provoke a violent response from his audience by telling them to go peacefully. Simi conceded that he relied on public speeches, and he's a TDS whisperer, and so he probably a lot of phone calls with Liz Cheney, blah, blah, blah. They say Trump was issuing a literal call to violence. Literal. Fight's not metaphorical. He's not referring to a political fight. He wants you executed. Okay, so the district court then used his testimony and they incorporated it into their factual findings of law. Then they came to their conclusions of law. The district court, Sarah Wallace, held that the Colorado Election Code does not allow the secretary to assess this under the 14th Amendment. Now, continuing, they say, the law says you can only do it in certain areas. Now, the district court went on to hold, though, that Trump did engage in an insurrection, but they ultimately concluded that Section 3 was inapplicable because Trump never took the oath. And therefore, it held that the presidency is not an office under the United States, and everything is inapplicable to Trump under the 14th Amendment. Sorry. Now, what happened was, of course, they took that up on appeal. The Anderson litigants and Donald Trump actually sought review in the Colorado Supreme Court. Trump said, first of all, I didn't engage in anything, and it wasn't an insurrection at all. So he wanted portions of that reversed as well. But the Colorado Supreme Court just reversed everybody. Says here, reversed, Trump goes off the ballot. Supreme Court, in their ruling, which we also read, first addressed whether the Anderson litigants could review and bring their claims. Of course, they found that they did. The court reached this conclusion by saying only qualified candidates can participate in the primary. Now, this is a restriction only on the political parties, and it does not require or even allow Crazy Eyes Griswold or the courts to purge individual candidates. Now, no one can test that the Colorado Republican Party had at least one presidential candidate who is indisputably entitled to be on there. That is all that is needed to show. All. Okay, this is kind of technical stuff, but in other words, they don't have even the mechanical rights in the statute to consider these other things. Colorado Supreme Court also held that a presidential candidate is not qualified, and he must be qualified before his name is added. Now, the court did not consider the possibility that a presidential candidate who's currently disqualified might become qualified. For example, somebody who's 34 could be 35, or somebody could reach the 14-year residency mark, or a candidate currently disqualified under Section 3 can seek congressional removal of disability, right? So that's a possibility too. So Trump could say, oh, if I am disabled, I want Congress to override that, right? Because the provision, the statute provides for that. The amendment, the 14th, provides for that. The court also dismissed out of hand that Trump's argument that Section 3 bars individuals from office and not running from office. And so having concluded that they could proceed, then the state Supreme Court actually moved on to the merits, right? All that was kind of technical nonsense. When we got there, it rejected Trump's due process challenge, said, no, everything was happening here perfectly. The trial was okay. It also held that disqualification imposed by Section 3 is self-executing, automatically attaches. You don't need Congress to do anything. And it rejected Trump's argument that this was a political question. And finally, the Supreme Court also reversed, said that Section 3 is applicable, that the president is an officer of the United States, and the presidency is an office, and that Trump engaged in an insurrection, rejected all of the other defenses. Said that he needs to go off the ballot. Anybody who writes his name in, you're done too. Now, the judges, also, 3 of them wrote dissenting opinions, and they made very good arguments. Justice Sommore also argued that they violated due process, discovery was denied, they rushed the proceedings, they based their factual findings on congressional hearsay, and their experts were of dubious reliability, largely because they have TDS. So they say, all right, all of that is the backdrop. Now, that was obviously a lot of procedural history. And they say, so given that this was all a disaster, this is what we're asking for now. Colorado Supreme Court has no authority, they tell SCOTUS, to deny President Trump access to the ballot. And by doing so, they have usurped congressional authority and misinterpreted and misapplied the text of the Constitution. The issues presented in this position are of exceptional importance, Supreme Court, and they urgently require your prompt resolution. saying the question presented in this petition are of utmost importance. President Trump is the leading candidate for the nomination of the President of the United States. In 2020, he got more than 74 million votes and more than 1.3 million votes in Colorado alone to be reelected as president. And thus the Colorado Supreme Court decision would unconstitutionally disenfranchise millions of voters in Colorado. And if you do it, it's likely going to be used as a template to disenfranchise tens of millions of voters nationwide. If you do it here, they're going to try it everywhere. And they're going to say the Supreme Court gives them permission to do it. Indeed, the Maine Secretary of State, in an administrative proceeding, has already used Colorado, okay, the domino effect we talk about, already picked the Colorado decision and strucken Trump from that state ballot. Now, President Trump has appealed over there as well, saying whenever there is a disputed question of presidential qualifications, SCOTUS, we have to let Congress decide what to do about it. Now, not all courts are suited for resolution of these complex issues. Congress, they say, not a state court, is the proper body to resolve questions about an eligible candidate. First, why? Well, the Constitution provides a role for Congress in resolving disputed presidential elections. For example, the Constitution specifically says, if the president-elect shall have failed to qualify, then the vice president shall act as the president until a president shall have qualified. And if there's a problem, Congress may provide a law wherein neither president-elect nor a vice president-elect shall have qualified, declaring who shall then act as president, or the manner in which one who is to act shall be selected accordingly. Now, they say here, the 14th Amendment itself embodies a clear textual commitment to Congress. So Congress deals with those issues. Congress deals with these issues. Congress, they wrote in Section 5 of the 14th Amendment, it says Congress, quote, shall have the power to enforce this article. There's no similar commitment to any other state courts. They don't ever say, we'll just give it to the states. Why don't we let Crazy Eyes Griswold, Secretary of Colorado, just decide? That's not in there. Considering the constitutional role for Congress, it's little surprise that every court except Colorado that has addressed this question has determined that the question is non-justiciable. It's reserved to Congress. In other words, this is not a question that you can even sue over. Take it to Congress. Indeed, every federal court that addressed this issue, whether Barack Obama was eligible, remember that? Regarding the eligibility of Barack Obama and John McCain and Ted Cruz, who some people say is the Zodiac killer. I don't know, maybe. That the issue was for Congress and not the federal courts. Okay, we've already said other people are ineligible with John McCain and everybody. They say, well, it's not our problem. It would be, says Trump, beyond absurd, particularly in light of the 14th Amendment's enlargement of federal authority, that this issue would be non-justiciable by the federal courts, yet properly heard and decided by courts in all 51 jurisdictions. The election of a president with the United States is a national matter with national implications that arises solely under the federal Constitution and does not implicate the inherent or the retained authority of the states. Now, in the absence of any enforcement legislation, Section 5 gives it over to Congress. But the Colorado Republican Committee, they've argued that Section 3 is not self-executing. And this court needs to answer that alone. Even if Section 3 does not require enforcement legislation to have effect, the lack of such legislation deprives the courts of judicially manageable standards. So in other words, if you're going to say Congress doesn't govern this and you're going to give it to the courts have no idea how to handle this, obviously. There's no safeguards, procedural mechanisms by which we can ensure that these are done appropriately. Procedurally, Section 3 is silent. There's no guidance there. Do we have a jury? Do we have a judge? Do we have a lone state election crazy eyes make decisions, make factual determinations? It's likewise silent. What's the standard of review? Is this preponderance of the evidence or beyond a reasonable doubt or clear and convincing evidence? What's the standard? Creating the prospect that some courts can just do whatever they want. Others will adopt preponderance. Others clear and convincing. Others may be criminal. Similarly, states have different approaches to voter standings. As a result, a voter in one state may be able to challenge somebody there while another state cannot. And substantively, terms like engage and insurrection, those are wild terms, varying standards of those. How do you even define that language? So resolving these conflicts requires making policy. And they have to compete amongst political and policy decisions. That is what Congress does, not the courts. Now, moreover, they say the result of the divergent standards and all the various determinations is particularly problematic when we do this during a presidential election. This court has already recognized back in 1983 that in the context of presidential elections, state-imposed restrictions implicate uniquely important national interests because the vice president and the president impact all the nation. And so by purporting to determine this, the Colorado Supreme Court overstepped their power and they usurped the power from Congress. Now we get into the meat and potatoes of the application of the 14th Amendment. And they say, this is Colorado Ballot's removal case at the Supreme Court. Trump's defense says Section 3 is inapplicable. Same thing that Sarah Wallace, the district judge, said. Section 3 begins with no person shall be a senator who has insurrected the country, okay? It lists offices in there. It says it does not list the presidency. Look at this. Anyone, no person shall be a senator, representative, elector of the president, not the president, the vice president or elector, or hold any office, civil, military, or any other thing. Doesn't say the presidency because the people can decide that. It does not list the presidency. It lists it highest to lowest. And so any office, civil or military, it's like a catch-all. They didn't like insert the presidency in there. Thus, to find that Section 3 includes the presidency, one must conclude that the drafters decided to bury the most visible and prominent national office in some catch-all term that includes low-ranking military officers. Now, this reading defies common sense and it's obviously incorrect. Now, similarly, the disqualification can apply only to those who have previously taken an oath as a member of Congress or as an officer. Now, as we know, Donald Trump, it is undisputed that President Trump never took an oath as a member of Congress or a state legislator or as a state executive or a judicial officer. So it does not apply to him. And lastly, Section 3 cannot apply to Trump unless the president is an officer of the United States. But if he is an officer, they say the Constitution makes clear the president is not an officer. The phrase officer of the United States appears in 3 provisions apart from Section 3, and in each of these provisions, the president is literally excluded. The Appointments Clause requires the president, who is the root power, to appoint ambassadors and to appoint all other officers of the United States. The officers of the United States are appointed by the president, which is the root power of the country. Here, the president does not and cannot appoint or commission himself. He cannot qualify as an officer of the United States when the Constitution draws a distinction between officers and the president who appoints them. It is a legal clarification, and it's logical also. The impeachment, like all of the power, is vested in that executive president. The impeachment clause further confirms that the president is not an officer. It says the president, vice president, and all civil officers of the United States, it disambiguated them, shall be removed from office on impeachment for and conviction of high crimes and treason. Now, the clause causes the president and the vice president to be separate. There is no basis for separating them out if they are also civil officers. Otherwise, they would just say all civil officers. And there's also the textual requirement that Section 3 applies only to those who took an oath to support the Constitution. That's an oath required by representatives, state legislatures, and others. The president swears a different oath. It's to preserve, protect, and defend the Constitution. Support is nowhere to be found by design. The argument that it's the same is conflating the two oaths. It's a clear contradiction because the president was not understood to be included as an officer of the United States. Now, the Colorado Supreme Court didn't care about any of that. They made no attempt to explain how, quote, officers of the United States can include a president when this phrase excludes the president everywhere it appears in the Constitution. The court should grant cert in this case, Supreme Court, because Trump never swore an oath as an officer of the United States. Continuing, arguing now that Trump also did not engage in an insurrection. Ridiculous. They say first, the events of January 6th were not an insurrection at all in the first place. Insurrection, as understood at the time of the passage of the 14th, meant taking up arms and waging war upon the United States. You know, because we had just come out of the Civil War. When considered in the context of the time, that makes sense. Why? Because we had a horrific civil war. 600,000 people died. And the very survival of the nation was in doubt. So focusing on war making was the logical result. But now, by contrast, the United States has a long history of political protests that have turned violent. For example, in the Summer of Love 2020, that Kamala was supporting by getting protesters bailed out of Minneapolis, violent protesters targeted federal courthouse in Portland for over 50 days. They repeatedly assaulted federal officers. They set fire to courthouse, all in support of a purported political agenda, opposing the authority of the United States. U.S. Homeland Security even issued a report about that. Now, 50 days, onslaught attacks, a pure political agenda organized, federal officers repeatedly assaulted, property damage day in and day out. Is that an insurrection? It's closer to one, but I would still say no, obviously not, right? That's kind of it's an onslaught protest, should have been dealt with. But are they going to take over the country? This is waging political war? I would say no. But it's much more substantial than anything that happened on January 6th. And by the way, during the Summer of Love, they also torched the 3rd precinct in Minneapolis. It was billions of dollars of damages, not under $3 million, that took place in the Capitol building. Billions. Now, in the context of the history of violent American protests, January 6th was not an insurrection, and thus no justification for this at all. Moreover, nothing that Trump did was engaged in an insurrection. He never told his supporters to enter the Capitol. He never told them to do anything at his speech at the Ellipse or in his statements elsewhere. To the contrary, his only explicit instructions, the only thing that he ever said, called for protesting peacefully and patriotically. What else did he say? To support our Capitol Police and law enforcement. He said to stay peaceful and to remain peaceful. But I guess all that is coded language that means execute Order 66 and eliminate Congress. Got it. So the Colorado Supreme Court, they then faulted Trump for not responding. They said he should have responded with alacrity when he learned the Capitol had been breached. Trump should have just opened up a live stream. Please stop it. And acted like, a hysterical Liz Cheney would have acted. That's not his prerogative. Okay, you're not the president. You don't get to decide how he responds to that. That is substituting your discretion for his. That is exactly what you're not supposed to do under Marbury, right? The court is not supposed to substitute and judge the president's discretion. Even, however, the Colorado Supreme Court conceded that not acting does not constitute engagement, they had to admit. And they said here the court should reverse because they said that Trump's speech would also be protected. And the state testimony relying on TDS Professor Simi also defer to his fact finding. And constitutional speech should not turn, and the protections should not turn on opinions from sociology professors like that guy. They say Colorado also violated the Electors Clause, telling us that the Electors Clause requires states to appoint electors in a manner that's consistent with the state legislatures. The Colorado Supreme Court ruling violates that. Why? Because the legislature allows the state judiciary to intervene and decide ballot disputes, but they don't have the authority to do that. Secretary Griswold cannot neglect her duty, any duty, which includes this. The Colorado Supreme Court tried to concoct a wrongful act by claiming that the secretary could address this stuff when it comes before her. But they then somehow managed to transform this statutory language so that Griswold would then violate the law, right? Griswold would violate the law if she failed to act. So basically they just perverted and adjusted the statutes to get whatever they wanted done. They say Section 3, in concluding, this is to the Supreme Court of the United States, saying Section 3 also prohibits individuals only from holding office, not running for office. Does not prevent anyone running or from being elected, because Congress can remove it. Congress can remove the disability. So if you're elected, maybe they don't take office, but they're elected to the office, and Congress can remove it. So that basis alone, okay, just because there's a logical possibility that that could happen, means that if you remove Trump, you are now violating those provisions. You're violating that possibility. Colorado claimed that it has no less authority to exclude Trump than a 28-year-old. But that's wrong. Congress has no authority to add additional qualifications to the Constitution, residency, or natural-born citizenship clause. Forcing Trump to prove that he is not disqualified before appearing on the ballot adds a new extra constitutional requirement. But the case U.S. term limits renders the states powerless. The states cannot alter the constitutional qualifications to this. Even the term limit dissenters acknowledge states are forbidden from prescribing qualifications to the presidency. That is for Congress to decide. The president, unlike members of Congress, represents and is elected by the entire nation, and allowing each of the 51 jurisdictions who are going to vote for the man to enforce their own qualifications is going to lead to national bedlam and voter confusion. And in what Colorado did is they added a new qualification. It's no different from the state enforcing some other new requirements, and they're not allowed to do that. So in each of these situations, a state that violates the rules by altering their qualifications is not allowed to do that. So you see Harmeet Dillon and others, Scott Gessler, David Warrington, and many others submitted this to the Supreme Court, writing in conclusion, the petition for a writ of certiorari to the United States Supreme Court deciding this Colorado Supreme Court ballot removal issue should accept the petition and reverse what they did in Colorado. Put Trump back on the ballot, say all of this was nonsense, no insurrection, 14th Amendment doesn't apply, Trump didn't engage in anything, and this is not something that secretaries of state can decide on their own. So we'll be here continuing to cover the replies. Of course, the Colorado lawyers will be filing their response to that. But this is what they have been saying when they've been making their rounds on the media. This is Eric Olson. He's appearing representing the plaintiffs in Colorado, and he is now responding to Trump's appeal, the one that we just read, which is extremely solid, that has nice structure to it, refutes all of the points, and I think the most obvious way possible. This is what his response is to what we just saw.
I think that any of the arguments that they're making here, in your view, are valid.
Well, they're arguments we've all seen before and have been rejected by the courts. He claims here, I guess the one new thing is he claims for the first time that no court, not even the United States Supreme Court, can determine whether someone engaged in an insurrection, and that he's above any judicial determination of what he did leading up to and on January 6th. That's just not the law, and we're confident the Supreme Court will reject that claim.
We just read it. I didn't
read
that.
I'm interested in part of the argument here, and this is something that we have gone round and round about when talking about this issue with legal experts, constitutional law experts, and it's an argument that, as the Trump legal team says here, even if the Supreme Court in Colorado could consider challenges to Trump's eligibility, that they misapplied the law because the president is not an officer of the United States and never took an oath as one, and that the presidency is not an office under the U.S.
Well, Caitlin, that argument has been raised several times. The overwhelming majority of scholars reject it, and properly so, because to give that argument effect would mean that Jefferson Davis, who led the Confederacy, led the Civil War against the United States, could have become its president shortly thereafter. There's no indication in historical record that that's what anyone intended. It was a broad ban applying to all those who held office and were officers, and the president was and is both.
So even as they kind of point out that there are other parts in the Constitution where it does lay out officers of the United States and it lists the presidency separately, you don't think that it's separate, even though it's referenced separately in other parts of the Constitution?
No, we think that the Colorado Supreme Court thoroughly addressed this question and properly held that the Constitution applies to everyone, and the purpose of Section 3 of the 14th Amendment was to prevent those that took an oath to support our Constitution and then engage in insurrection from holding office again. And there is no reason whatsoever to think that they left out the most powerful person in our democracy, the president, from that prohibition. Again, Jefferson Davis could become president under this theory. There's no basis in law or history for
if
that
he
to be
ran and the
case.
country would have voted for him.
When it comes to this and the questions of, you look back at history and what it tells you, but when we're looking ahead to what the Supreme Court is going to do here, do you think that they will take this case up? And if so, are you still hoping to get a decision as soon as February 11th?
We certainly expect they will take the case. Every party to the case has urged them to take it. We disagree a little about what questions they should take, but every party has urged them to take it. And if they don't take this one, there's more behind. There's ones coming from Maine and perhaps other states.
Of course there are.
So the court will need to address this case
onslaught.
quickly. This is an ideal vehicle to do it. As to whether they'll decide it by February 11th, voters in Colorado receive their ballots on February 12th. We've asked the court to work quickly here to issue a briefing schedule and argument schedule that allows them to complete a decision by February 11th so that those voters in Colorado and elsewhere on Super Tuesday have the benefit of knowing whether Donald Trump is disqualified.
Wild. Isn't that wild? So in other words, Trump would be on the ballot. You could go fill in the bubble for him in your primary, our Colorado friends out there. And then the court could come back down, right? Theoretically, I don't think it's going to happen. And then you would vote for him and they would just delete those votes. Gone. Just deleted. No, he's not qualified. Sorry, he can't be on there. And then they'll turn around and call us insurrectionists in America as they're disenfranchising every single one of those votes. They're stealing the election. I mean, they're actually trying to steal it openly using the courts. It's wild.
If they do take it, how tough do you think the fight's going to be for your side?
I think this court has shown a willingness to step aside from sort of the partisan frame on these hard issues that are important to our democracy. We're optimistic that, as did the Colorado Supreme Court, that when you look closely at the legal arguments and evidence presented here, there really isn't a close case here. Donald Trump engaged in an insurrection against the Constitution, and therefore, under the Constitution, he cannot be our president again.
Incredible. So these are the people fighting for democracy by taking away your right to vote for somebody in a democratic process, in a democratic election. And they will sit there with their dead eyes and just tell us that this is in our own interests because Trump has been disqualified. So here's another person with some crazy eyes. Crazy Eyes Griswold is back, and she showed up here. You can just see this woman has another level to this. She posted this on her own account. Says the American people deserve to know whether a president can engage in insurrection and then return to office. And she just has, some fake hearing where they present facts from Liz Cheney, literally gobble up her report. And that is the determination about whether someone has engaged in insurrection. Here's Jena on MSNBC doing her thing.
Frankly, the American people deserve to know whether a president can engage in insurrection and then be qualified once again to hold that office.
As in what you see in Donald Trump's petition to the Supreme Court, is there anything there in their petition that shapes your view of this case as opposed to the Colorado Supreme Court's view of the case?
I would qualify it as more of the same to a large extent, lies that we've heard since 2020. Donald Trump is trying to argue he did not incite an insurrection. Well, 2 Colorado courts at this point have determined that he did. And then Trump goes on to argue that even if he did incite the insurrection, well, the Constitution doesn't apply to him. I don't think that's right. I don't think that there's some get out of jail free card for the presidency that allows Donald Trump to escape scrutiny of the laws of the land and the Constitution. So I do think it's important for the United States Supreme Court to act quickly, even if that action is determining that they will not review the case. That, in effect, would basically put Colorado Supreme Court's case in full power and would disqualify the former president.
All right, so same talking points that you hear. No president get out of jail free card. All that kind of stuff. No one's above the law. Engaged in insurrection. 2 courts have found. Blah blah blah. Same stuff. These people You can feel their rage, can't you? You can read it in their eyeballs. Like, they're not apolitical people. They are not people who are just trying to make sure that they're operating the levers of the legal system to get qualified candidates on them. Not at all. They are partisan hacks who absolutely detest Donald Trump. And they are on a political mission to get him off the ballot. They're trying to steal the country right in front of us, like right now, by saying you can't even vote for the guy. And even if they lose, which I also have my concerns about, the Supreme Court, I don't think they're going to do this, but they could say it's a states' right issue. Maybe, something they would get Thomas to recuse. We know Roberts is very squishy. Now we deal with this like 4-4 situation. I don't know. But it's beside the point. The point is these people's intention, everything that they're doing, they're working to do is to steal the election right now away from you. You don't even get to vote. And we cannot forget that. Okay, when this small issue moves on, hopefully the Supreme Court settles it. But that's what they're doing. And they run the elections. They are running the elections. So if Trump gets on the ballot, she's still running it. She's the Secretary of State. So all of the things, all the people that are working for her, all of the mechanics are still being operated under the umbrella of deranged, crazy eyes, psycho. So, it's not good. It's not good. We can't lose sight of that. So, all right. So that's Jena Griswold, AKA Crazy Eyes. Let's hear from some of Trump's people. This is a former Trump attorney who was brought on to respond to some of this on with Tapper. Here is Tapper asking Mr. Tim Parlatore about this. And let's get some volume queued up on this. And here we go.
So long to appeal that Colorado Supreme Court decision to ban him from the ballot, because frankly, I thought that they were going to move more quickly.
Why would they move fast?
I would have expected them to move more quickly too. I don't have any specific knowledge other than, as you know, one of the reasons why I left that team is...
I would say that you would delay it so that you don't have an opportunity to get him off the ballots, right? There's a stay in place right now. So there's no rush. Just leave the status quo. He's going to be on the ballots right now. So, okay. You want to get as close as you can until the actual day of the vote. There's a lot less likelihood, lot less likely to remove him if there is no decision than if there is a decision. So there's no rush.
Interference, from other people. So I could imagine that, this was definitely litigation by committee of going back and forth with drafts. And I mean, Dave Warrington, who filed the brief, is a very smart lawyer. I would expect him to do good work and do it fast. But if he's being interfered with by others, then that would delay it.
Who are the others that interfere?
No. Come on.
Well, in my experience, it was people related to the campaign, like Boris
Epstein. Yeah. Do you think the U.S. Supreme Court is going to take this up?
I do. It's a situation where you have a significant split between the states of an issue that really does have vital national importance as to, whether, people in different states are going to be given the same choice as to who they're allowed to vote for president. So I think that, if there is ever a case that falls squarely within the mission of the Supreme Court to solve these issues, this is it. So I can't imagine them rejecting it.
Yeah, it's a big problem especially if they decline this, then Colorado is going to just say, okay, success, right? We're done. And other states will follow suit. There will be the floodgates of ballot removal lawsuits all over the place, and they'll just rely on Colorado. It would be total bedlam, which is why I think that there's no way they can allow that to happen. This is Byron Donalds also responding to this. Of course, he says, here's my message to Shenna Bellows. Shenna is over in Maine. She's the other one who just removed Trump because Colorado. Like, my friend Crazy Eyes Jena did it, so I can do it too. Yay. And says, hey, my message to Shenna. You're going to lose in court, Byron says. Your people you're turning people away. This is going to backfire and worsen things. And you also exposed your radicalism. Again, another Shenna who's going to run the election. So she's openly trying to get Trump removed. And if she doesn't get him removed, she's the referee. She's the person who is now going to be governing how the elections are covered. Okay, what about signature, all of it, all of the mechanics are governed by this person. So do you think it's going to be a fair election in Maine? says these people don't care about laws or institutions at all. They don't care at all. They only care about winning. Byron is exactly right. Says we must rid our system of this rot. He's right.
My message overall is you're going to lose anyway. But when you do stupid stuff like this, what you're really doing is you're turning off independent voters and even some of those soft Democrats, those conservative Democrats. Yes, they exist in the country. They're voters. They're not electeds, but they're conservative leaning and they're also Democrat registered voters. You start turning people off because what you're saying is that you would rather just disenfranchise a segment of the country. You would rather just remove political opposition as opposed to actually having the political process take its natural course. So I think this is going to backfire. It's already backfired, and it's only going to get worse. But this is really proof of the radicalism that is in the Democrat Party. I mean, we're not talking about political disagreements or, somebody who's very liberal or somebody who's very conservative. These are radicals, people who don't care about the rule of law. They don't care about our institutions. They only care about their agenda and winning elections by any means necessary. That is the rot in our country, and we got to get rid of it.
And they'll tell us they're doing it for us, to save American democracy, because they can't let an insurrectionist on there. And it's, well, if they are really concerned that he's an insurrectionist and everybody knows he's an insurrectionist, then why don't we just let the people decide? Because the people don't think that. They think that in their deluded mental state. So we're going to be here continuing to cover this, my friends. Trump is submitting his petition. Not Jack Smith, the Colorado people are going to be submitting their reply. We'll see if the Supreme Court picks it up. Thank you for subscribing wherever it is you're watching this. Thanks for also checking out watcherlodge.com, our newest project. We have our fitness challenge underway right now. You can sign up all the way through January 5th. Just go over there, check out the lodge, the fitness challenge. One good thing every day for 31 days for yourself, something health related. And it can be, hard or it can be easy. But come and join us. We're giving away some prizes, giving away some scholarships. And you have up until January 5th to sign up. Come and join us. We have a lot of fun, great comments, people sharing some good fitness advice at watcherlodge.com. Of course, we're going to be here covering all of the Trump saga. Thank you for subscribing and sharing this with a friend or family member. And we'll look forward to seeing you back here on the next one. All right, my friends. Now, let's turn our attention over to Jack Smith, the illegitimate Jack, because Trump is now filing against him. Donald Trump says Jack Smith should be held in contempt of court for continuing his prosecution of Trump on the January 6th case in Judge Chutkan's courtroom, even though the case is on appeal in the D.C. Circuit Court. We've been following both these cases closely, and we've been asking ourselves the same question. Why is Jack Smith, who's illegitimate, by the way, according to former AG Ed Meese, why is he continuing to disclose notices to Trump? Why is he continuing to provide evidence and ask the judge to issue rulings or accept all of it? Case is on pause, Jack. Judge Chutkan said it's all held in abeyance. And so you can't continue to prosecute Trump when the case is on appeal for your illegal prosecution. And so Trump said, and we're excited to see this, Jack is violating your orders, Judge, and he should be held in contempt for doing so. We're going to read through the filing. Trump's campaign had a response, and then we'll hear some reaction on the J6 stuff from Pelosi and, of course, Karine, because the White House is making this a centerpiece of their campaign. So straight to the filing, Trump asking that Jack Smith be held in contempt of court. Cases, of course, out of the District of Columbia. We're back in Judge Chutkan's courtroom. U.S. versus Donald Trump. Here's what Trump's defense says. President Trump is now filing this opposed motion, Jack Smith not happy about this, for an order to show cause on why prosecutors like Jack should not be held in contempt of court. And we know these people. President Trump respectfully moves this court for an order to show cause as to why prosecutors like the illegitimate Jack Smith, Molly Gaston, highlighter girl, and Thomas Wyndham, why they should not be held in contempt for violating this court's order. Because Chutkan, you said that all this case was stayed pending any further proceedings, and that you are staying any further proceedings that would move this case towards trial or impose additional burdens of litigation on Trump. That was from Judge Chutkan's order. And so what's happening is they are dumping a bunch of additional burdens of litigation on Trump. And why are they doing that? Trump says, You know, Judge Chutkan, the stay order that you wrote is pretty clear. It's pretty straightforward and unambiguous. Nice job on that. Now, all substantive proceedings pursuant to your order, Judge, are halted. Now, despite the clarity of your order, Judge, Jack Smith and these prosecutors, they began violating the stay almost immediately. And why is that? Because we've talked about this. They want the case to go back to trial on March 4th. Super Tuesday is March 5th. Jack Smith, if he doesn't get the trial scheduled in March, man, he's going to be running out of time, because we got a May trial in the Florida case that might move. We've got election season coming up. They're not going to want to reschedule it like in October. Maybe she will. Who knows? So he wants to keep going. While the case is on hold, he's saying, no, I'm going full speed. Because when the Court of Appeals, I think, is going to affirm what some part of Chutkan and going to send this all back down. In other words, the motions to dismiss are not going to be granted. So the case will come back down, and Jack Smith is going to say, perfect, we've still got time to have this trial in March. So he just keeps this train going, while Trump said, literally, I cannot be in two places at once. Okay, I cannot be in Judge Chutkan courtroom being prosecuted when I'm appealing all of your garbage up here in the Court of Appeals. And the law says that too. Defendants cannot be in two places at once, so everything in Chutkan's courtroom is on hold. So when that order went in, that Jack Smith didn't care. First, within 5 days of the court entering the stay order, the prosecutors, they just dumped thousands of pages of additional discovery right on Trump's desk. Here you go, eat it. And we say, wait a minute. The judge told us that we don't have any additional burdens of litigation right now. So why are you dumping this discovery on us? They also drafted a purported draft exhibit list. Now, through counsel, President Trump advised them. He said, we reject your productions here. Get them out of here. We rejected the prosecutors' unlawful productions, and that we said their actions are violating the court order. And he said, we're going to seek relief if you guys continue this malicious conduct against us. We don't want your discovery. We're not in this courtroom. Pack it up. Get it the heck out of here. Now, ignoring this warning, Jack Smith, the illegitimate prosecutor, filed an expansive motion in limine that we read here. Okay, he just filed this whole motion. Less than 10 days later, he's like, I don't care. This document teems with partisan rhetoric, includes false claims that President Trump propagates irrelevant disinformation within the courtroom and outside of it. And moreover, the motion in limine mirrors the Biden administration's dishonest talking points, asserting again, falsely, that President Trump was responsible for J6, when in truth, Trump called for peaceful and patriotic assembly during the protest. In this manner, the prosecutors seek to weaponize this stay to spread political propaganda, knowing that Trump would not fully respond because this court relieved him of the burdens of litigation. So now that Jack Smith is airing out, all this propaganda, and Trump can't respond. Worse, though, the prosecutors have announced their intention to continue this partisan-driven misconduct indefinitely, effectively converting this court's docket into an arm of the Biden campaign. Now, to remedy this outrageous conduct, says Trump's defense, this court should issue an order to show cause as to why Jack Smith and highlighter girl Molly should not be held in contempt, required to immediately withdraw their motion in limine and their garbage discovery that were improper, and be forbidden from submitting any other further documents. And also, I love this, they also want monetary sanctions in the amount of Trump's reasonable attorney's fees and expenses incurred for having to deal with their improper productions and filings. Love that. All right, Jack, cough up some money, and our fees are not cheap. We're $1,000 an hour starting. They say this case, Judge Chutkan, as you know, presents weighty questions of first impression. We got immunity, impeachment judgment clause, double jeopardy. Now, we moved in your courtroom to dismiss on these grounds, and you denied us erroneously. So we appealed you to the Court of Appeals. And they say this entire case is essentially involved in the appeal. We already explained the entire case must be stayed. Okay, there's this Coinbase case that came out in 2023 that they have been latching onto, which is just incredible. And they say, we already explained that when we appeal this, these burdens of litigations are all halted. And the doctrine protects Trump personally and also the public interest in minimizing the chilling effect that litigation would have on the discretionary conduct of public officials. But in response, Jack Smith doesn't care. Now, he agreed, actually, that while the appeal is pending, that he's not going to be subject to the burdens of litigation. But he said that Trump could somehow continue to shoulder its own burden and advance the case in Trump's absence. In other words, Jack Smith says, well, Trump doesn't need to file anything, but I can file my stuff. I can do my homework, right? But what they said is prosecutors meant by that statement that they would attempt to unconstitutionally try President Trump in absentia by just continuing the prosecution with him not being there. No. He is there. He's just at the Court of Appeals. Now, they're going to continue to submit their filings, and so they say the prosecutors brought further error upon themselves by saying that the court could make headway on the motions. Now, the court rejected this unprecedented and unlawful approach. They said, sorry, we have to stay. Okay, this is what Jack Smith wanted. But Chutkan said, nope, we have to stay any further proceedings. Sorry, that's what the law says. And that stay includes everything, deadlines and proceedings and everything. The judge hated that. And to ensure that prosecutors did not correctly believe that the court had endorsed this lawlessness, they provided only two limitations on the stay. They said that the stayed deadlines are held in abeyance. So if the Court of Appeals comes back very quickly, then maybe she can say, we're back, and then it's going to go to the Court of Appeals, and then it's not back. But so it's held in abeyance, so we're going to hold on to those deadlines. And they say the court also has mechanisms to enforce the gag order, all right? So she says, I can cover the gag. But nothing else. The court distinguished the above exemptions. Now, but despite this clear guidance, Jack Smith, they immediately violated this order. They filed 4,000 pages of additional discovery, and they sent over a production letter that had several hundred video and audio recordings. The next day, the prosecutors then continued their brazen misconduct by serving more exhibits. The prosecution's only explanation for this harassment of President Trump was their already rejected claim that this was necessary. They say, well, we need to do this, though, to ensure that the trial proceeds promptly if and when the mandate returns, because they want the trial to happen like now. But worse, the prosecutors also misrepresented the stay order. They claimed that the only deadlines in the pretrial order were held in abeyance, only the deadlines. But in fact, no, the deadlines and the proceedings were held in abeyance, and any further proceedings are also held in abeyance. And so the prosecution's claimed justifications that their filings and their discovery are necessary to prepare this case for trial, that's exactly what the order forbids. Trump has patiently explained this to Jack Smith, both in responses to their letters and in a separate letter. We told them, we said, hey, Jack, idiot, there is no question that your present discovery and draft exhibit lists are, quote, proceedings. The prosecution admitted as much. And so you're violating these orders. Now, although, Jack, you may wish to rush this case to an early and to an unconstitutional trial in hopes of undermining Trump's commanding lead, you still have to abide by the order. Now, as such, we will not accept, we are not going to review anything that you send over. And if you continue to violate this, we're going to seek relief. Well, they said Jack Smith, those losers over there, did not respond to either the letter or the response. They did, however, attempt to exploit the stay order. They wanted to go seek certiorari before judgment to the Supreme Court. In other words, they tried to leapfrog even the Court of Appeals. They advised the Supreme Court that Trump's appeal, Jack whined, Trump's appeal has halted the progress towards the trial. And the effect of the appeal stays all the proceedings, and all the deadlines are also stayed. In short, they said, now the case is on hold. So why are they still dumping off discovery? Now, nowhere in this recitation did the prosecutors adopt their discredited and unsupportable claim that the proceedings only stayed the deadlines, but the proceedings were also on. So they're talking out of both sides of their mouths. Not a surprise. Now, unpersuaded, Supreme Court denied their desperate ploy for early review. Sorry, Jack. So when they failed at the Supreme Court, Jack then resumed the strategy and filed his motion in limine back in December. Now, aware that their submission was improper, they tellingly did not confer with Trump before they filed it. They are such garbage. Oh my gosh. Okay, so the standard practice in law, right, is you ask the other side, hey, I'm going to file this motion. Do you have any objection to it? Of course we object. No, we don't object. We see it here. Oftentimes there's a consent motion, right? There was just a consent motion in Florida, I think, to allow electronic devices. Government agrees. Yeah, sure, let this in. So here, Jack Smith is like, we're just not even it's like you don't want to talk to the other person. You know, like when you go to a meeting and you kind of secretly hope the other person doesn't show up. You're like, should I text them to say I'm here? Well, if I text them, then they're going to know about the meeting or whatever, you know, kind of a thing. So they're like, we're just going to file this and hopefully Trump doesn't notice. So they filed it. And unsurprisingly, they suddenly forgot their histrionics regarding the all-encompassing scope of the order. Instead, the prosecutors returned to their twisted view that the stay order is merely a suggestion, meaning less than the paper it is written on. That's your order, Judge Chutkin. They're taking your order and dumping all over it. Once again, the prosecutors falsely claim that the only deadlines are held in abeyance and that any further present. And once more, the prosecutors admitted their goal is to achieve exactly what the stay order forbids. Okay, stay says you're done with litigation, and they are literally continuing to prepare for trial, which they arrogantly presuppose will occur. Man, I love this motion. I can't wait to see who wrote it. Yet this is not the prosecutor's only unlawful goal. Unstated but obvious is the prosecutor's desperate effort to harass Trump and prevent his likely victory in the 2024 election. You got that right. A significant part of this strategy, which the prosecutors have employed from the outset, is to use this case as a platform to advance the Biden campaign's dishonest political talking points, for example, echoing the false and defamatory claims that Trump spreads disinformation. Likewise, Jack and Molly, they dutifully repeat the Biden administration's long debunked claim that Trump somehow caused January 6th. In truth, Trump called for peaceful and patriotic assembly. Many people have reported this. Now, as it did on True Social, the Biden campaign improperly seeks to inject its message into this case. And the prosecutors are more than happy to oblige. They don't care about your order, Chutkin. Indeed, the prosecutors are undoubtedly anticipating the political talking points that they strategically placed in the motion in limine. They want them to spread like wildfire. They want them to go to every single news outlet out there who's just doing their bidding. It's all just one big incestuous, disgusting cabal. And of course they did. CNN picked it up right there. Rachel Weiner picked it up. The Washington Post, Alexander Malin picked it up. ABC News picked it up. They all took it. So they give us some law. They say, look, the law is pretty clear here, okay? When you file the notice of appeal, Judge Chutkin, and this was fun to read through here if you missed those filings, those were great too. Chutkin, you have no jurisdiction, is what they said. You are done. You don't have the right to keep this case. And they were right. She didn't. They say here, it is currently unnecessary to decide whether the court retains residual jurisdiction. We don't need to get into that. But there is no dispute that there is a problem here, and thus any contempt proceedings following from their violation of the stay orders need to be considered. Now here, a court may remedy the violation of a stay with civil contempt proceedings. We're allowed to do this. And here, Jack Smith committed repeated and willful violations of this. The court did not leave the prosecutor's obligations under the state a chance. Okay, the judge, when she wrote this, was clear. But it's clear that the prosecution planned from the outset to violate this stay, and they've done it. It was a straightforward order. The court was equally clear about what would not be allowed, and there is no doubt that the order is clear. And the order specifically requires no additional burdens of litigation. But Jack Smith have failed to comply with this. Each prosecutor violation has been in turn. One was a large discovery prosecution. There was also an extensive exhibit list production. There was also a lengthy motion in limine. Those are 3 for 3, 3 strikes, and they're not even responding to our requests. Now, taken together with the prosecution's threat to continue violating this indefinitely, there is no question here that the prosecutor's actions are purposely contemptuous, Judge. They're violating your order. The conduct is beyond the pale, and it must be sanctioned. And fourth, Jack Smith has no justification for their misconduct. Even if their intent were a consideration, they did not violate the stay order inadvertently. Trump explained why and has already warned them, stop your violations. But they submitted a brief to the Supreme Court saying, we're screwed, man. Can you please help us? Like they know they're out of time, so they're freaked. Yet they violated the stay order again. These are not accidents. Their submissions were planned. They were intentional. They knew that they were backed into a corner, and they freely admit this. They want to advance the case quickly. They said it when they filed it at SCOTUS. Now, for the same reason, they say the prosecutors cannot then have it both ways. They never sought any clarification. They just started filing motions. And they purposefully did not even confer with Trump's counsel before filing their final motion. These repeated and intentional and malicious actions demonstrate the prosecutors have not once attempted to comply with the stay order, but have instead openly defied it from day one. And so sanctions are appropriate here. As an initial matter, the court should order the prosecutors, deranged thug Jack Smith, who's illegitimate, to immediately withdraw their motions and their improper productions. Come pick up your boxes of crap here. These are the primary violations, and they continue to cause harm to Trump. Now, although Trump has, consistent with his rights, refused to accept and to substantively respond to these documents, the only way to obtain compliance from these recalcitrant prosecutors is to force them to acknowledge their wrongdoing and to affirmatively withdraw their offensive actions. And next, the court should also require Jack and others to obtain permission before filing any other additional documents here. The prosecutors have shown repeatedly that they are unwilling to act in good faith. They've announced their intention to violate the stay order, and so a pre-clearance requirement for these deranged thugs feels appropriate. And lastly, the court should require that Jack Smith compensate President Trump for his damages that he sustained. Namely, Jack Smith should reimburse President Trump for all reasonable attorney's fees, which, man, are going to be expensive, that he has incurred. This would include the cost of preparing his response and letter and litigating this motion. And in this district, a contempt award often includes reasonable costs. And this is sensible here. And so we want an award of fees because this is considering the harm that he's already imposed of us. This request is quite modest, actually. And a lesser reward would not adequately deter Jack Smith's conduct. The special counsel's office has spent untold millions of dollars, including over $9.2 million in just 4 months before November 18th through March 31st. $9.2 million. Now, although the prosecutors may scarcely feel the impact of paying Trump's reasonable fees, especially given the expenses of Biden administration giving them a blank check, at the very least, it's going to signal their continued violations will not come without a cost. Whew. Yeah, Jack, cough it up, brother. The parties and the prosecutors are not ordinary parties to a controversy, but they're representatives of a sovereign. And in a criminal prosecution, it's about justice. Now, the prosecutors here, Jack, Molly, and Thomas, they have cast these hallowed mandates aside. They're here to score cheap political points against President Trump on behalf of the Biden campaign. And in doing so, Jack Smith has repeatedly and willfully disregarded Judge Chutkan's explicit instructions. And such malignant conduct undermines the integrity of this proceeding and warrants severe action. This court, Judge Chutkan, you cannot allow Jack Smith to continue to operate lawlessly in defiance of the well-established protocol of this court's authority. Our requested sanctions are appropriate, and they are likely to deter any future transgressions. And if not, this court has the ability to impose some more severe sanctions, including dismissal of this entire case. And so accordingly, this court should order the prosecutors to show cause as to why they should not be sanctioned and held in contempt by you, Judge Chutkan. Now, as a good attorney has done, counsel for President Trump conferred with counsel for Jack Smith, and they oppose the relief requested herein. That's nice that they asked. Jack Smith doesn't ask anymore. When he files his motions in limine, they asked, and Jack, hey, Jack, you piece of garbage. Guess what? We're going to file a motion to hold you in contempt. Ask for an order to show cause. What do you have an opinion on that? Oh gosh, that'd be a great phone call to make. Hey Molly, it's Rob. Guess what's up? What do you think? Oh man, that sounds so fun. All right. So John Lauro submitted that one. Shout out to John Lauro. Shout out to Todd Blanche. That was a fun and beautiful motion. Absolutely love it. And this has been a lot of fun to watch because they're kind of baiting them a little bit. Trump's going on the offense now. He's saying, okay, Judge Chutkan, you want to keep playing this stupid game? Let's do it. So now Jack Smith is going to reply to this. Oh, don't hold me in contempt. I have a right to file all these motions, and the judge can hold them in, and then the judge can decide this. And we'll see what the judge does. But I'm very excited to watch this, because now this also anchors in another point. When the case does come back down, and I fully suspect that it will, Trump is going to rely back on this. Okay, he's etching this into the judicial record. He's saying, I have already told you, we're not reading your stupid discovery. We're not looking at your stupid exhibit list, and we're not replying to your motion to eliminate. So go get bent. And when Chutkan comes back and says, well, you can read it all, you can really litigate, you can go fast, like trial's back on in March, they're going to say, no, actually, no. We're litigating this now because we have told you we are not looking at your files ever again until we have to. Thanks for playing. So great filing, a lot of fun. Really enjoyed that one. This is the campaign statement from Donald Trump. They posted this in response to their own filing. They said, look, President Trump has filed a powerhouse motion. I agree, it was great. To hold crooked Joe Biden's henchman, deranged Jack Smith, in contempt of court for repeatedly violating the stay order in the Washington, D.C. J6 witch hunt. Jack Smith was ordered to not take any further action in the trial court until the immunity issue was resolved, which should be a full dismissal of the case because President Trump was carrying out his duty as president to investigate the rigged and stolen presidential election. But rather than respect the rule of law, Jack Smith unilaterally decided to disobey the stay order and continue with his harassing litigation, all done in order to keep parroting the pathetic Biden campaign's corrupt talking points in the name of election interference. As a result, President Trump is seeking to hold Jack Smith, the deranged thug, in contempt of court. No prosecutor is above the law. But love that. Okay, so Stephen Chung, Trump spokesman, confirming what they have filed. Delicious stuff. We're going to be here. Thanks for subscribing to continue this one. Of course, Jack Smith is going to issue a response. But here is Pelosi. Some people might say one of the organizers of the January 6th insurrection, because she was there with her sergeant at arms in the House, talking about why they can't respond to Stephen Son, the Capitol Hill chief of police at the time. But she's out now saying that Trump is responsible for insurrecting the country, the same talking points we're familiar with.
Because we don't agonize, we organize. What's his name was running for president, said Obamacare sucks. We say no, the Affordable Care Act cures. So all of these things are related. And what happened on January 6th was a manifestation of an assault on the personal freedoms that we have, because it assaulted the Congress, the Capitol, the Constitution of the United States. Because we don't.
She kind of sounds drunk, right? She kind of sounds like she's got marbles in her mouth, kind of slurring all over the place. But all right, that's about what we expect from that side. Someone else who's probably not drunk but also has a hard time talking is Karine. Karine is asked a question because this is the new agenda from Joe Biden. Everything's January 6th. We've got the insurrection anniversary coming up. Can't wait to celebrate with you guys. And we have the question from Joe Biden. Okay, Joe says it's insurrection, 14th Amendment, all this. Who is he relying on? Who are his scholarly advisors who are coming up with this term? Here is Karine.
Is there a list of the scholars and the historians that the press office said he had lunch with today in the lead up to the January 6th?
I don't have a list to share at this time. For folks who are not tracking, this afternoon the president met or had lunch with a group of scholars and historians to discuss ongoing threats to our democracy, whether here and also abroad.
Who are those
this
people?
is something that he tends to do, especially as we head towards an important day like January 6th. So it's something that it is commonly done. He's done it. He's met with a diverse group of historians before. I don't have a list to provide to you.
Don't know who those people are. Don't have a list of it. So, okay, who's he talking? Is Liz Cheney there? Is she there? Can someone tell us? Someone needs to look into that. So, all right. So maybe it was Nancy Pelosi's teeth. I'm hearing. Maybe it could be that. I'm not sure. So that's what's going on there in the Democratic Party, meeting with scholars and mumbling through drunken TV appearances. Jack Smith absolutely should be held in contempt. And we're excited to see what his team says in response to this. Why are you guys filing motions when you shouldn't be? The case is being held in abeyance, on pause, while the appeal is pending. And so Jack Smith acting very contemptuously. And we'll be here to continue to cover it, my friends. Now, before we wrap up, I want to invite you to come over to watcherlodge.com, our newest project for this month. We've got Watcher Lodge. We have a fitness challenge that's happening right now. You can sign up all the way through January 5th if you want to come and join us. We're going to be doing one good thing for ourselves, health-related, for 31 days, and we're giving away some prizes. Cash prize, we've got some lodge scholarships, and some fun stuff because we want to be fit. We want to outlift the tyrants who are out there trying to wreck the country. And so Jack Smith acting contemptuously. We'll be here continuing to cover it, my friends. Thanks for subscribing. Thanks for coming over, checking out Watcher Lodge and robertgovea.com to sign up for our newsletter. And we'll look forward to seeing you back here on the next one. All right. And so we got one final segment on the day. And this is the Ray Epps saga that is continuing on. And we know this is about what we expect. Ray Epps gets a 6-month sentencing recommendation from the Department of Justice, which is pretty incredible given the fact that Ray Epps was this guy standing outside the Capitol screaming, "We're going into the Capitol the day before." And Ray Epps was also there at the first breach, screaming into Ryan Samsel's ear, who knows what's there. But he gets a 6-month plea deal or sentencing recommendation, while we have other people who were there on J6 who did conduct much less serious than this, who are getting much more significant penalties. And so we're going to go through the Department of Justice's, their own sentencing recommendation, which really reads more like a defense attorney's sentencing recommendation, before we hear from Ray Epps himself, because he wrote a letter to the judge saying, "Tucker Carlson attacked me and I'm scared." So we're going to read from that. We've also got another interesting J6 defendant known as FreeStateWill on X at FreeStateWill. Great follow, somebody who's doing amazing work and really fighting hard in this arena. And he's asking a very interesting question. You know, if Ray Epps gets a 6-month deal, I can't wait till I get my 6-month deal from the Department of Justice, since equal protection, you know, no one's above the law and everything's kind of congruent, isn't it? We'll see. But this is what the Department of Justice, that they call themselves, which is just laughable. Here's what they've submitted on behalf of Ray Epps. Okay, this is Ray Epps, who took a plea deal. Now he's getting ready for sentencing. And here's what the government says. They say, "The United States of America, by the Attorney General out of Columbia, we are now here submitting our sentencing memorandum against Ray Epps. And here's what we want." Now, just for context, we know that the Oath Keepers, they're going to prison for a long time. Okay, and by the way, Ray Epps, just so we're familiar, was a former Oath Keeper, if you're not familiar with that story. Not only was he there screaming to go into the Capitol and, you know, encouraging people to violence, in my opinion, from what I saw, he also was a former Oath Keeper, okay, which is the same thing that Stuart Rhodes was. And Stuart Rhodes is going to prison for over 20 years, I believe. A long time. So you just compare and contrast this to the other Oath Keepers who got decades in prison. Ray Epps, they say, the government, this is the DC J6 prosecutors, we request that this court sentence to Ray Epps to 6 months incarceration. 6 months, that's it. Which is the high end of the applicable guidelines. So the judge, the sentencing guidelines based on the plea deal, can go all the way down to 0. Isn't that fun? So Ray Epps could maybe get no time. We'll see. The government is going to ask for the max, which is 6. Ray Epps and his team are going to ask for 0, the minimum. And then we'll get something maybe in the middle. And if he does get time, he's going to get, you know, credit for time for, you know, he'll go in. He's not going to serve the full 6, in other words, what I'm saying. And the government also requests a $500 restitution fee. 6 months, $500 restitution, and 1 year of supervised release, which is incredible because he was one of the most outspoken insurrectionists on the whole thing. Like, the internet knows this guy because he was so outspoken. It's not a random thing. We're all asking ourselves, why was this guy, by the way, he was also on the FBI's most wanted list for violent insurrectionists. Okay, so during the first wave of all this, before somebody figured out who this guy actually was, he was on the most wanted list. Not just any most wanted list, violent most wanted list. And then they figured out who he was, and suddenly they didn't need him anymore. So here's the introduction. This is from the DOJ, the so-called Justice Department. Okay. They say Ray Epps is a 62-year-old former Marine. He's a roofer. He's a handyman. He's a farmer. He's a venue operator, and he's now retired. Okay, this is what a defense attorney would say. He participated in the January 6th attack. Like, look at that. He's a roofer. He's a handyman. He's a farmer. He's a venue operator. And he's now retired. It's like, okay. Does he also walk little old ladies across the street, and like volunteer at his local community? What are you talking about? Prosecutors don't write this way. They say he participated in the J6 attack on the Capitol, a violent attack that interrupted Congress, and that threatened the peaceful transfer of power, injured more than 100 police officers, and resulted in $2.9 million in damages, which is like nothing. Billions were lost in the summer of love. Okay, and they keep throwing that number around. It's like meaningless. Now, as of January 7th, 2023, 2.9 million, and that's the loss. Anyways. Now, Epps pleaded guilty to, a totally rigged indictment, in my opinion, a pre-indictment. So he had a deal before he got charged. Okay, most other people, they get charged first, and then they get arrested, and then they get locked up, mugshotted, fingerprinted, the whole thing. Then they get pretrial conferences, there's pretrial proceedings, and then they get a plea deal. Not Ray Epps. Ray Epps took a plea deal before he was even indicted. Pre-indictment. And what did they give him? Oh, disorderly conduct. Great. Which is the most generic term ever in the history of criminal law. Were you acting disorderly? Yeah. Did you disturb the peace and well-being of other people around you? Yeah. Okay. That's why it's a 6-month max potential penalty, but certainly everything else is appropriate. 0 time. So the government's recommended sentence is supported by Epps's efforts. He, on January 5th and the day of January 6th, inspired and gathered a crowd to storm the Capitol, actively screaming about this. He was also present among the vanguard of rioters that overwhelmed the police at 3 key breach points, which opened the floodgates to a mob that became thousands strong. It's like, wait, you're telling us that he was at 3 key breach points? And he was at the vanguard, and he was inspiring all of these people? Wow. He also had presence and general assistance. He pushed a large metal framed sign into a group of police officers holding a defensive line, smashing this sign into the police. Rah! He also participated in a rugby scrum-like group effort to push past the same line of police officers. Sounds like violence. Probably why he was on the FBI's most wanted list. Now, the court must also consider that his conduct on January 6th, like the conduct of other defendants, took place in the context of a large and violent riot that relied on numbers to overwhelm the police, which probably wouldn't have been overwhelmed if they would have just accepted Trump's help to bring in the National Guard, but they rejected that. They say this is a unique case. Okay, that's interesting because there were a lot of J6ers who've been prosecuted. We've covered a lot of them here. Although Epps engaged in felonious conduct, his case includes a variety of distinctive and compelling mitigating factors. Wow. And that led the government to exercise its prosecutorial discretion. And we offered Ray Epps a pre-indictment misdemeanor plea deal. Okay, let's see. They say, first of all, Ray Epps turned himself into the FBI early, 2 days after the FBI. January 8th, he immediately became aware that the FBI was trying to identify him because he was on the most wanted violent list. He cooperated with both the FBI and Congress, gave Liz Cheney everything she wants, multiple lengthy voluntary interviews, which were horrendous. We read the deposition here for Ray Epps, the full 80, 90-pager. That video's on our channel. But you remember in that interview, he said he went into the Capitol. Now, they keep saying he didn't, but we read it as though he said, I did. Now, the transcript was so botched because all the Congress people were asking questions simultaneously, and they muddled it up intentionally so he couldn't see who was asking and who was answering. But the point is, in my opinion, there's enough evidence to say this dude went into the building. Anyways, he engaged in at least 5 efforts on January 6th to de-escalate the conflict, and he tried to avoid violence. Oh, that's nice. He also expressed what appears to be sincere remorse. He's so sorry. Although he continues to blame members of Antifa, Ray Epps continues to speciously blame members of Antifa, secretly posing as Trump supporters for the violence, which is probably true. He says, finally, Epps has been the target of a false and widespread conspiracy theory that he was an undercover government agent on J6. And they forgot a period here. Now, here, after accounting For the aggravating and all the mitigating factors, we got all these problems like Ray Epps at 3 different breaches, Ray Epps screaming at people to go into the Capitol. Ray Epps was a former Oath Keeper. He also turned himself in early and he's really sorry about it. Okay. So after accounting for all of these things, we get a recommendation of 6 months of incarceration. Saying here, to avoid unnecessary exposition, the government refers to the general summary of the attack on the Capitol. In the evening of January 5th, Ray Epps stood amidst the crowd. He was there at the BLM Plaza. It's so wild that they have a whole plaza there after they torched the country in 2020, but okay. In response to people around him proclaiming their anger at and their desire to fight Antifa and BLM, Epps said, "Tonight you can bring shame on us. That's not what this is about." Another person challenged Epps. And Epps said, "We're far beyond that. In fact, tomorrow," Ray Epps said this. He said, "I don't even like to say it because I'll be arrested. We need to go in to the Capitol. We're here to defend the Constitution. I'm just going to put this out there. I'm probably going to jail for it," says Ray. "Tomorrow, we need to go into the Capitol. Into the Capitol," he said peacefully. Now, other than his 4 years in service, Epps has never been a government employee or an agent, which nobody was ever saying. Again, I don't think Ray Epps showed up and got a badge, government FBI informant, or that he's on HR. Nobody's saying that. But he was an Oath Keeper. He is getting 6 months in jail. A lot of other people are not. Let's see. Epps' speech was recorded and broadcast over social media. We remember this one. That's him screaming, "Into the Capitol. Into the Capitol." And people there are saying, this dude's a Fed. He's wearing a beige shirt, desert camouflage, brown backpack, says Trump all over the place. Epps was recorded telling one group. He said, Epps said, "As soon as the president is done speaking, we go to the Capitol. The Capitol is this way." He said, "As soon as Trump is finished speaking, we're going to the Capitol. It's that direction. That's where our true problems lie." When Trump began speaking, Epps, along with many others, left the rally, walked right towards the Capitol. At 12:52, when Trump was still addressing the crowd, a small group of people, including Epps, and this is the government speaking, they assembled near the monument. Bicycle barricades had area signs closed. Shortly after, the mob of rioters reached this outermost barrier, which was unguarded by officers. It's crazy. They know 1 million people are going to be there. A barrier is unguarded. When Trump said, "Can we maybe have the National Guard there?" They just walk right in. Rioters, and Ray Epps walked them right to it. Rioters threw the barricades aside, and the crowd, including Ray Epps, who's funneling people, like with the airplane things, this way, right to the Capitol. Come on this way. Go left into the building. Perfect. Ray Epps, who was standing nearby at the very front, surged forward. He surged forward, breaching the first line of defense for the Capitol grounds and entering the restricted area. Ray Epps, the first one through. 6 months. Okay. Now, after the breach of the outer perimeter, scores of people advanced past the trampled barricades. Approximately 100 feet up the walkway, the crowd approached a second set of barricades, which were guarded by a small group of Capitol Police officers, a couple guys. Give them the new guys, too. Give them the interns. Send them out there. Here's the scene. We remember this. Ryan Samsel, who's also being prosecuted, says less than 1 minute after arriving at the second barricade, members of the crowd grew agitated. One member of the crowd, black shirt, later identified as Samsel, turned his baseball cap around. Epps was standing at the very forefront of the mob of rioters. Epps right at the front. And here it says Epps approached Ryan Samsel and spoke in his ear. Now, we don't know what he said, but Epps, throughout various interviews, he's repeatedly said that he whispered something like he said, "Dude, relax. The cops are just doing their job right there. Dude, relax. Cops are just doing their job." Now, Samsel has provided multiple contradictory statements, and so the government does not include this incident where Epps was attempting to de-escalate. Of course not, because he was there, orchestrating people into it. We're going into the Capitol, going into the Capitol, going into the Capitol. And then suddenly he stops right here and he says, "Hey, everybody calm down." Okay, so they continue. They tell us, seconds later, at 12:54, the group of rioters on the front line aggressively shook the barricades and attacked the officers trying to stop them. With Epps standing nearby and looking on, there's Ray. Oh, perfect. The rioters violently overwhelmed the officers and they destroyed the barricades and surged forward. So at that moment, right, if Ray Epps is like, I'm done, I don't want to be any part of this, he leaves, right? He's gone. I don't want to be involved in this. Knocking over the barricades, Epps is just looking on because he's so innocent. Now, the flood of rioters, again, with Epps near the front, they then storm through the down barricades. And Ray Epps is right there. He's running through it, further penetrating the restricted area, setting an example, literally leading other rioters to follow. He opened a wide path for the mob to do this. It's Ray Epps right there, front of the pack, breaching everything. Now, a short way down to the path, a group of rioters, including Epps, they encountered a third set of barriers, a waist-high fixed metal fence. They just threw those out of the way. And once again, Epps, again, near the front. This is the DOJ who's going to give him 6 months, they're writing this. He rushed past a third set of down barricades and continued to penetrate the restricted Capitol grounds. By 1 p.m., less than 10 minutes after being outside the outer perimeter, Epps and a group of other large rioters made their way to the West Plaza, a restricted area on the Capitol grounds just outside the Capitol building. There they are. There's Ray Epps tucked away in the corner down there. Still very active. Now, lines of uniformed Capitol Police and MPD officers were there to stop their further advance, but rioters continued to assault them with fists and pepper spray and flagpoles. But they were ultimately able to reform a line and push the crowd away from the building. This is the exhibit here. You can see this yellow line, which is the line. Meanwhile, an unrelated group of rioters wheeled a large Trump sign. Okay, so Ray Epps, he's now all over the place. See that large Trump sign right there? Well, Ray Epps is going to be involved in that. Maybe he wanted that Trump sign specifically. Maybe he, I don't know where it came from, which measured 8 feet by 10 feet tall. Now, while the sign itself was made of fabric, it was metal in frame. Once the group arrived, the rioters gathered, they lifted it overhead, and they passed it across the crowd like it was being crowd surfed. Now, when the sign reached the middle of the plaza where Epps was standing, rioters worked together to turn the sign 90 degrees, and they pushed it towards the officers. During the group push, Epps briefly placed both of his hands near or on the sign's fabric and or frame for several seconds. Sounds like pushing it. Why are they writing it this way? Briefly place both of his... Is he holding on to it for like leverage? Like at a stall or something? What's he doing? He's pushing this into the police. That's an attack on the officers. So why is he getting a disorderly conduct charge? Why isn't this assault on the police? Epps appeared to reach for the sign, both as it passed overhead and after it cleared his space. Reaching. Okay. Now, once the sign was beyond reach, Epps pointed forward toward the line of police officers several times. Pointing. Cops are that way. Seconds later, at 1:40, other rioters did it. They successfully pushed the sign into a group of the police that Ray Epps helped to get there. The sign's immense size and forcible impact broke and scattered the police line. Ray Epps was there doing it. The officers managed to wrest the sign away from the rioters, but while officers were occupied with the sign, a group of rioters, including Epps, pushed forward in its wake, leaning their bodies on each other like a rugby scrum. This is the DOJ admitting that Ray Epps did all of this, by the way. This is not my interpretation or the defense or anybody else. And they're giving him 6 months for this. Now, police officers responded by deploying chemical spray on the rioters, and the rioters, including Epps, immediately fell back undispersed. But Ray Epps remained on the Capitol for another 30 minutes. Evidence shows that during this time on the Capitol, both before and after his participation as described above, Epps made 5 attempts to de-escalate the conflicts, I'm sure, including with attacking police. Specifically, Epps walked back and forth in a few feet of space between the line of police and the mob, and on multiple occasions, he tried to persuade hostile rioters who seemed primed for violence. He said, calm down. For example, Epps walked up to one rioter just as the rioter was yelling at a police officer. He was saying, somebody was saying, take that swing, take a swing at me, MFer, take that swing. What are you saying? Speak up, take off that effing thing. I'd love to get on it. I've come locked and loaded. Epps put his hand on the rioter and he said, sir, touches him on his shoulder. Sir, take a step back. Take a step back. We're holding ground. We're not trying to get people hurt. They don't want to get hurt. You don't want, he's saying we're holding ground. So he's part clearly of this so-called insurrection. We've made our point. It doesn't matter. Just back up. We don't want to take away from what we did. What Ray did. Taking ownership for it. So Epps then continued down the line. He said other things. When Epps returned, he told a rioter, he said, all right, they have a job. They have a job. Don't beat up the cops. Now, while still in the West Plaza, Epps relied on earlier text messages from his nephew. Nephew said, told Epps, be safe. Wrote, I'm in. Epps replied to an earlier text message to his nephew, telling Epps to be safe. He wrote, Ray Epps said this, I was in front with a few others. Ray Epps says, quote, I also orchestrated it. I also orchestrated it. That's Ray Epps' own words, admitting, I also orchestrated it. Which is crazy because other people who orchestrated the insurrection were charged with seditious conspiracy. They're going to prison for 20 years, talking about the Oath Keepers. Stewart Rhodes, who was his friend, by the way. They were walking together, marching together in Arizona. Ray Epps was marching literally with Stewart Rhodes at Oath Keeper proceedings in Arizona. Stewart Rhodes going to prison for 20 plus years, Ray Epps going for 6 months. I don't know why. Stewart Rhodes wasn't even there at the Capitol, by the way. No violence, no signs, didn't throw anything at anybody. Was not even there. 20 years. Epps left the Capitol grounds soon after. He did not enter the Capitol building, which I totally still disagree with, by Ray Epps' own deposition. I don't trust that. Until we've reviewed every single hour of the 444,000 hours of video or whatever, I don't believe that. I think Ray Epps did go into the building. We read the transcripts here. He says, I went in. He said, I went in. Anyways, now, he didn't go into, let's say, the Senate chamber. I would say that's probably true. But we saw it in his depot. Now, shortly after leaving the Capitol grounds, Epps gave an interview to an unknown individual. That was recorded. The interviewer summarized Epps' position as follows. They said, so you're saying you're marching down there, and it's one more thing that we as patriots can do to show these elected officials, look, we didn't just come out here to jump around and yell and scream. We came here to be visible. We came here to make a point. And that's right where you are, right? That's exactly what you're saying. You want these guys to know? Epps then agreed with the interviewer's summary. All right. So then Ray Epps, of course, showed up on the FBI's most wanted list. On January 6th, the FBI posted online a number of photographs of, quote, persons of interest, violence at the Capitol. Photograph 16 was Ray Epps right there. So the person who was assembling all these said, we got to get the most violent people first. Go get them. Ray Epps is on the list. 2 days later, though, Epps called the tip line. Hey, that's me. He gave a lengthy consensual interview about his activities, and he admitted that he attended Stop the Steal. He also admitted to observing other rioters tear down barricades. And then he came in on March 3rd, 2021. His lawyer was there. They interviewed and participated in consensual follow-up interviews with the FBI. Epps identified himself in photographs. He stated when the word started to spread that the riot goers were going to the Capitol, he decided to help spread the message. He wanted to be front of the pack. He said he understood that he was trespassing, and while he intended to enter, he did not intend to break in. His goal was to walk in the front door and just protest. So then he went and met with the J6ers. Now, beginning with an article published by Revolver, great article, Epps became the centerpiece of a conspiracy theory for J6. According to the conspiracy, he was an undercover federal agent or something. Informant. Doesn't necessarily need to be an agent or an actual government person. Epps then became a polarizing figure, got a lot of attention. They say Epps, who has never been a government employee or an agent, which again, we're not saying that, other than his 4 years of service in the Marines, was interviewed by the Select Committee, illegally constituted. Epps cooperated with Congress. The transcript of his interview is available. It's a terrible transcript. And in my opinion, he admits he went into the Capitol. Now, during the interview, he admitted, okay, again, that his goal was to get as many people into the Capitol as we can, surround it, let them know we're not happy with what happened. When they asked him what the step was, when he asked about orchestrating it, he says, well, I mean, I just helped get people there. And I took credit because I was proud that we were there. But at the time, I didn't see the whole picture. Okay, I got caught up in something, just like many other people did. He was unaware of the extent of violence and damage that ensued, just like a lot of other people did. Now, he described the riot as terrible and sad, but he said this conspiracy He says that the actual violence there was undercover members of Antifa posing as Trump supporters and trying to hijack a righteous protest, which I think is probably true. Now, on September 18th, the United States charged Epps with 1 count of disorderly conduct. Total joke. He pled guilty. He's got to pay $500 in restitution to the architect of the Capitol. Now, as noted, they say the plea agreement, he could face up to 12 months imprisonment pursuant to the plea. They're not asking for that. They're asking for 6. Supreme Court has said that we got to follow the guidelines. Ray Epps went to probation. They determined his criminal likelihood of reoffending and all the things. They say we are now looking at the sentencing guidelines, and we agree with probation that this section does not apply. Specifically, Epps contributed to the rioters' push of a metal frame into a group, and he did participate in a rugby scrum. But we are aware of 3 cases in which the courts have rejected that application. And they're giving us other cases. And the government, the court should also not apply this subsection because the J6 riot was a violent attack that threatened the lives of legislators. 2.9 million in other damages. Many rioters collectively disrupted this. And we also have this provision talking about the recidivism rates. And due to the unique nature of this, there's not, we're going to ask that this sentence is appropriate to deter a person like this. And so finally, to avoid unnecessary litigation, if you decide to apply this to sentencing, we can do it this way. Here are the factors. They tell us, this is the nature and the circumstances of the offense. The attack on the Capitol was a grave attack. And while Epps' participation in the attack, you should consider that. You should also consider the various factors. The most important factor here, Epps encouraged the mob to storm the Capitol. He was present at the breach of the first 3 barricades, overwhelming the police with force and mass. He contributed to the movement of the Trump sign. He participated in a group push against the police. Even if Epps did not physically touch law enforcement or go inside the building, which I disagree with, he undoubtedly engaged in collective aggressive conduct. Yeah, collective aggressive conduct. Is that not violent conduct? Like if they wanted to punish him, they would say he was attacking the police. He was using signs to thrust the sign into the heroic cops. But the mob's size is what made it so powerful. The police were massively outnumbered and overwhelmed. And Epps was not just one person among many, however. Beginning in the middle of the night, he worked to build that mob, to build the size of it. He was a tall, loud, repetitive messenger. He was one of the primary cheerleaders in the crowd, advocating for breaching the perimeter that was restricted. He was encouraging people to go into the building en masse. He was at the very forefront of the group. He breached the first barricades. Now, while he did not tear down any fencing himself, he immediately and eagerly ran behind those that did. His presence and large stature, his 6'4" size, contributed to the power, the mass, and the weight of the mob. And these emboldened others as they were going in behind him. With people like Epps setting the example and leading the way, thousands followed and stormed the Capitol. So don't you punish the person who's like the front person? Like, isn't that why Enrique Tarrio got hit hard? Isn't that why Stuart Rhodes is getting hit the hardest? Ray Epps was the prime mover. Now, in this way, and by his own admissions, Epps literally assisted in turning a trickle of people that the police could have contained into a flood that they could not. Maybe the whole thing doesn't happen but for Ray Epps. Now, once he got inside, he was connected and he participated in 2 violent incidents. First, Epps used the sign as a battering ram against police officers. And a preponderance of the evidence suggests that Epps was aware of this and even contributed to it. He even attempted to reach for the sign after it cleared his space. And once it was beyond his grasp, he pointed forward towards the police and towards their line. Even if he did not intend to harm them, it was the effect of his actions. This sounds like bad stuff, man. It's like, wow. One Capitol Police officer described the sign's frame as so heavy it took 15 officers to remove the sign. Other courts have found that the use of a sign as a battering ram is assault with a dangerous weapon. That's weird. Is Ray Epps charged with that? No. After the sign crashed and broke the police line, the mob of rioters, which included Epps, surged forward. They took advantage. They pushed back, and Epps's large size was an asset. Also, the night before, he worked to build the size of the mob. He left the rally to march before Trump was even done speaking. He ran to be in the front of the group. When those agitators broke down the signs, Epps was right behind them. Epps and the other rioters cleared a path and inspired others to engage in dangerous and lawless behavior as well. And once inside, once the West Plaza, he was an instrumental presence. Accordingly, they say the nature and the circumstances of this offense establish the clear need for a serious sentence of just 6 months in jail. All of that. 6 months in jail. It's nuts. It's insane, okay? Because Stuart Rhodes is 20 plus years. Enrique Tarrio, I think, is 17, 18 years. Those guys weren't there. Ray Epps was physically there leading the charge. They give him 6 months in jail. And they call it a serious sentence. This is your Department of Justice, who cries every single time they even think about Donald Trump. It's crazy. Now, it's obviously a double standard. There's obviously something more going on here, but we'll finish. Now, as set forth, Epps served 4 years in the Marines, honorably discharged, military training. He's also someone with capabilities, you'd presume. Now, while his military service is laudable, it makes this conduct even more troubling. True, former military member, particularly one with specialized training, Epps knew better. But Epps's case is unlike others. This is why he gets a smoking sweetheart deal. His repeated attempts to de-escalate the conflict, his immediate and fulsome cooperation with law enforcement just 2 days after the riot, and the widespread impact by the conspiracy theory. What? They're going to say that because we think there's something askew here, because there obviously is, that he was acting as a federal agent. And again, we're not saying that he was acting as a federal agent who's like employed with a badge, but something went down here. Sounds like this guy orchestrated, by their own admission, and by his own admission, I orchestrated it. He admits it. They admit it. We're saying that he was an orchestrator for something, right? You gave him a sweetheart deal for doing it. A theory that continues to affect him, but it also undermines the integrity of the ongoing and overall federal prosecution. So you see, that's why they're mad, because Ray Epps is being used to show that they are not a justice agency at all. They show it themselves. They don't need Ray Epps to point it out. Ray Epps is just like an obvious example. It's a symbol. It's a flag post. We can all see it. Okay, he's literally a big, tall dude. So other than his 4 year as in the Marines, Epps has never been a federal agent. Yes, we don't think he collected a paycheck from you. Got it. He was not a federal agent or working at the direction of a federal agent on January 6th or in January. So again, I think this is just, prosecutor speak. This is just garbage, FBI speak. No, of course not. Your informants are not working at the direction of you. You're not directing them to do things for you. But they're like, for example, do you think the FBI would say we directed the Whitmer defendants to do anything? Of course not. Now, Epps only acted in furtherance of his own misguided belief that I'm sure that they exacerbated had been stolen. Now, however, due to the outrage that's directed at Epps as a result of that false conspiracy, which we doubt, he has been forced to sell his business. He's been forced to move to a different state. Let me ask you this. Do you think any other J6ers have been forced to sell their businesses or to close their businesses? Do you think any other J6ers have been forced to move? Any other J6ers have been forced to live reclusively? Like, does that justify a 6-month sentence? Defendants has suffered adverse ancillary consequences to their lives. Many have lost their jobs, and sentence courts have generally rejected arguments about that. We've already been punished enough by society. But why are they including that here then? So the court should also note that Epps identified himself just 2 days after the riot as soon as he discovered the FBI was seeking info about him. He then provided several reliable information, during several key interviews. So what came out of those interviews, right? This guy's setting everything up and then orchestrating the whole thing and then turning it all over to the feds. Why did that happen? Now, the need for the sentence reflects the seriousness of the offense. His 6-month sentence, which I'll maybe do 4 on, even if the judge gives him the 6, They say the attack on the Capitol was an attack on the rule of law. And so we cannot ever deal with this if this was just simply a political protest. And this is an attack on democracy itself. And so we have deterrence goals. We have to deter people from doing this. We've got general deterrence and specific deterrence. So general crimes are deterred by putting people in prison. And what about Ray Epps? Well, we don't really need specific deterrence for him because he turned himself in voluntarily and already spoke at length. He already gave Liz Cheney whatever she wanted. And so even though this caused damage to the democracy of America, a just punishment has to deter Epps. Among other things, Epps appears to continue to believe that concerns by him and others, he continues to believe questions about the legitimacy of the presidential election justified the storming of the Capitol. So Epps is not even, he's still an insurrectionist? He appears to continue to believe that concerns of him and others about the legitimacy justified the storming of the Capitol. So other people go in front of the judges and they say, I regret everything. I've rejected everything. I think that Joe Biden's amazing. He's the president for sure. And the judges still say, I don't care. You're going to jail for 3 years, 5 years. Go away. Not Ray Epps, though. Ray Epps is like, no, it was still rigged, and I'd do it again. Moreover, Epps explained his own presence at the storefront of the rioters, who broke through the initial barricades with the unapologetic statement. He said, Marines are always in the front, not in the back. Now, despite his own time in service to the nation, Epps failed to recognize that this aphorism refers to Marines acting as the tip of the spear for the government, not against the government. And he gave a bunch of interviews on 60 Minutes, the New York Times, and other things. He assures the government that Epps would not take additional action if he thought it was justified or that his presence would be helpful. And so the court must sentence Epps in a manner that's sufficient to deter him. Now, they say, as the court is aware, we need to avoid unwarranted sentencing disparities. Epps is getting 6 months. As the court is aware, the government has charged hundreds of individuals for their role in this, and the court must sentence Epps based on his own conduct and the relevant characteristics. No previously sentenced case contains the same balancing of the aggravating and the mitigating factors here. Epps's case is unique. And they gave him one, just totally ridiculous charge, disorderly conduct. It's a Class A misdemeanor, didn't even charge him with a felony. And while Epps's case is unique, other judges have sentenced Capitol breach defendants according to relevant cases there. For example, they say in United States versus Brendan Straka, while Straka did not enter the Capitol building, he did hold others, and the judge sentenced him to 3 months of home detention. All right, so he got a good deal. Now, while both Straka and Epps helped build the mob, Epps did so over a longer time period than Straka. And so they give us some more case law here. But we don't want sentencing disparities. Neither do we. Yeah, a bunch of other, they should go back and give the Oath Keepers, the rest of the Oath Keepers, 6 month sentences. Now, the Victim and the Witness Protection Act says the following, and it says here, the principles are straightforward. The parties agreed Epps has $500 in restitution. That's it. So, sentencing requires the careful balancing of these things. This is the DOJ. And so Ray Epps needs a serious, very serious 6 months in jail, 6 months in prison. Why? So he learns about the consequences of his behavior. And while recognizing, accepting responsibility, he also de-escalated conflicts, and he also cooperated with the feds and Congress. Therefore, 6 months is appropriate, according to Michael M. Gordon, who is a part of the Capitol Siege section. Really tough guys over there. And this is a joke, right? Obviously, we've covered so many J6 cases here. It's like, what? They go through and they whitewash all of his misconduct. He was at the tip of the spear by his own admission, orchestrating the whole thing. 6 months? Now, to be fair, like if they want to give 6 months to everybody who's even close to that, that's an improvement. They can go back and we can apply that to every single J6er and see if it applies. Now, Ray Epps also submitted a letter to the judge. He says, hey, dear Judge Boasberg, I know I'm going to be sentenced soon, but the guilt, remorse, and humiliation that I put my wife and my family through has been overwhelming. The past 2 years of harassment and threats and being forced to repeatedly move to try to hide from people is making my life difficult. Now I, says Ray Epps, I am a peaceful follower of Jesus Christ. I had what I thought at the time were valid concerns. I traveled to D.C. to accompany my son. I take full responsibility for trespassing. Now I put myself and my wife and family through a nightmare. I've let them all down. I'm sincerely sorry for going to Washington. I do not regret trying to calm people down and de-escalate. Your Honor, I want you to know I love the United States. Now, I do now and have always believed that our Constitution was God-inspired, and as such, the most correct way for our freedom and happiness on earth. I also believe in the democratic process, and I've learned a lot. I've also learned not to put my trust in politicians. Fox News and some other media and social media outlets have betrayed me with their election lies. And then when the lies were exposed, they created a conspiracy to blame the insurrection on me. The blame of the insurrection is not on the FBI. I think it is. It's on those who are at the Capitol and engaged in those insurrectionist activities and those who misled Americans like myself. Now, Your Honor, my decision to attend J6 has been devastating to my family. The resulting impact has fragmented our families, taken our livelihood, and impacted our health. Yeah, I believe you shouldn't have been there, doing those things. And it's wild that you're getting a 6-month sentence. Like, I understand people make mistakes. I'm regretful. I'm remorseful. I'm angry at myself for attending. A lot of other J6ers feel this way, but they're not getting 6 months, okay? They're not getting the DOJ that whitewashes their crimes or alleged crimes. So the question is about another J6er. You may know this man, FreeStateWill on the X platform. He's also pretty shocked about this 6-month deal. He says, incredible. He's been charged with J6 crimes. At FreeStateWill on the X writes, I have filed a motion to dismiss charges in my case. Why? Due to selective prosecution. Now, while the government alleges that Mr. Ray Epps engaged in felonious conduct, as they did, we just read that, they charged him with a single misdemeanor. That's weird. He was assaulting police with a sign. Disorderly conduct, though. Or why they indicted me on 8 counts and they ignored the same mitigating factors for him. So make sure you're following FreeStateWill. He's filing his own motions here, doing a great job. And this is what this one looks like. 4 pages. This is a motion for a discovery and dismissal of the charges due to selective prosecution by the DOJ, which just gave Ray Epps a 6-month deal. He says, on February 12th, I was arrested in Topeka, Kansas. Ray Epps never got arrested. It was a pre-indictment charge under allegations related to the Capitol events. On February 17th, says Mr. Pope, the government filed an 8-count indictment against me, alleging even though I was entirely nonviolent, unlike Ray Epps, the government erroneously believed that I'd violated federal statutes. He says on September 18th, the government filed a 1-count information against Ray Epps. Ray Epps, they said, disorderly conduct. Now, Epps was allowed, not arrested, to arrange a plea agreement before charges were brought, and he pled guilty to a single charge at his very initial hearing. By contrast, the government promised to allow me to self-report if charges were brought against me, but instead, that didn't happen. The government showed up to my house with armed officers to arrest me, and they made me spend 5 days in jail before giving me an initial hearing, before that could take place before a magistrate judge. Nice. Now, my conduct, he says, is distinct from Epps in that I did not urge anyone to go into the Capitol on January 5th and January 6th. I did not leave the president's speech early, and I was not one of the people to first run onto the Capitol grounds like Epps was. I also did not push a sign into police officers, but the government claims in their sentencing memorandums that a variety of distinctive and compelling mitigating factors apply to Ray Epps, that they led the government to exercise their prosecutorial discretion, and that they could offer Ray Epps a pre-indictment misdemeanor, even though he engaged in felonious conduct. Now, among the mitigating factors that the government listed was that Ray Epps turned himself into the FBI, that Epps cooperated with the FBI, gave interviews, that Epps attempted to de-escalate individuals on J6. But in my case, the government seemingly ignored these same mitigating factors, even though I was not a provocateur like Epps. and I did not assault the police with a sign like Epps did. I, says Mr. Pope, reported my presence to the FBI's tip website on January 9th, the first full day I was back home in Kansas, and I participated in an interview with the FBI soon thereafter. In fact, I did this despite not being on the FBI wanted list like Ray Epps was. Didn't show up on the most wanted violent list. On January 6th, my brother and I also had friendly interactions with the Capitol Police, and we de-escalated an individual who was banging on the marble with one of the stanchions that held the velvet ropes. We voluntarily left the building, and my brother fist bumped an officer right before walking out the memorial doors. We also left the Capitol grounds before Ray Epps did. As Jason Crawford, the former prosecutor assigned to this case, correctly noted, I was entirely peaceful on January 6th. Ray Epps was not. He was in a rugby scrum. Yet despite me being entirely peaceful, while Epps was provoking the crowds and assaulting police, and despite the same mitigating factors being present in my case, the government has treated me much more severely than Epps. They have brought 8 charges against me rather than 1, and rather than offering a single misdemeanor plea, the government tried to force me to plead to obstruction of an official proceeding, a felony, with a 20-year max sentence. 6 months for Ray, 20 years for this guy. Now, with mitigating factors thus being equal, it seems the government has engaged in discriminatory and selective prosecution on the basis of some bias or unjustifiable standard. This unjustified arbitrary classification may be that I had run for local office in Kansas, or maybe that I was enrolled in a PhD program at Kansas State, or that I had spent more than a year of my life living as the only white man in an all-black town, or that I had led dialogues on racial diversity for the National Park Service, or it could be my religion, or that I was engaged in journalistic activities that the prosecutor resented. Oh, he's outspoken. Oh, that's the problem. Or that the government favors persons who provoke crowds to do things that the government prosecutes, like Mr. Epps did, over those who don't. Or that the prosecutors resented me being better looking than themselves. Boom! So true. FreeStateWill is a good-looking man, and prosecutors are hideous. That's why they all look the same, because they're all contorted with their injustice energy. It's like the dark side. You know, like in Star Wars when his face gets all wrinkled up? That's them. Gosh, they're ugly. And William is handsome. Good-looking dude. Or it could be any other unjustified or arbitrary discrimination which are prohibited by the United States case law. But clearly, Lady Justice has not weighed all things equally. The government has bestowed favor upon Ray Epps, and they have not bestowed equally on me. I therefore move this court to dismiss all charges in my case with prejudice due to selective prosecution by these ugly prosecutors, or in the absence of an immediate dismissal to compel discovery be produced for why, oh why, was Mr. Epps being given the government's unjustified and arbitrary favor. Amazing. From the very handsome William Pope, filing this on his own out of Topeka, Kansas, and sending this in to the DOJ. Amazing. And I think it's really very useful. Okay, this is a very useful motion because it first of all, is absolutely true, but it so beautifully is a compare and contrast to what happened and the double standards that exist. They want 20 years for obstruction because they're ugly and because he has an outspoken X account. In the ECF filing, the DOJ incorrectly alleged that I reported my presence on J12. Not true. My phone records show I did not visit the TIP website after January 9th, the correct date. I have also communication records. I told several persons on J9 that I had reported. I've got communication records with my brother on J6, on J8. I only waited until January 9th to report because my brother wanted to consult an attorney first, which is good advice. So amazing. This is William Pope who submitted this, and we're hopeful that he's very successful in this because there are major double standards here, and he is able to articulate it quite clearly for us. And so, my friends, I would encourage you to go and follow him. He's doing really great work on the X platform. And of course, he's at FreeStateWill, which looks like this right there. At FreeStateWill, been charged with crimes by our Injustice Department, fighting his case aggressively and articulating and exposing for all of us to see the double standard that is out there. And so if you want to follow this X post, I have re-X'd it, reposted it on my account at FreeStateWill. We're here and pulling for you, my friend. So thanks for your amazing work. Motion to dismiss. We hope it is accepted because it is a double standard. Ray Epps gets 6 months and they want other people to go to prison for literal decades for conduct that is less serious than Ray's. So what's going on? You can be the judge of that, but there is more to this story, in my humble opinion, than the DOJ is letting on. They're going to tell us this is a serious, serious sentence for this guy who may have orchestrated the whole thing. So we'll be here continuing to cover this, my friends. Thank you for subscribing. Thanks for sharing this with a friend or family member so they can see what's happening for the J6ers who are going through this saga. We'll be here continuing to cover. Thanks for checking out robertgovea.com. Sign up for our daily newsletter there. We also have all of the PDFs are available there. So if you want to read any of the PDFs or get a summary of the show, robertgovea.com is the place to go. We also have our merch store. We got our newest merches there at the robertgovea.com shop. You can get the Watcher symbol on the hat and sport it proudly. It's Justicia, it's Libertas, it's Lady Liberty. It's got the sword to cut through the bonds of ignorance, the shield so we can defend our communities and identify ourselves. And we're grateful for your support, supporting the work that we do here on the show. Grab some gear at robertgovea.com/shop. We'll be back. We'll see what Ray Epps ultimately gets. Thanks for subscribing and joining us as we do. All right, my friends. Well, that is it for us on the day. We covered some good ground here. Ray Epps, 6 months jail. We've got Trump saying Jack Smith should be held in contempt. We've got Trump also going to the Supreme Court to try to reverse the Colorado decision. And of course, we're going to go over to our members only after party at watchingthewatchers.locals.com to wrap it up. We might have to do a separate thread today, but we'll get there. But before we do, if you want to join us, we do members only streams in the morning. We do Saturday shows. We already had a beautiful stream this morning. We have an awesome community, so come check us out. watchingthewatchers.locals.com. Now, on the day, we got some good comments in the house. Kaleem is our newest supporter. And so for our YouTube members, don't forget to grab the Telegram link on the community tab section, and we'll see you at the after party on Telegram. We've also got Lori is coming in. Lori W is our newest supporter. Welcome aboard, Lori. Great to see you. We got Drew in the house bringing in, what's up, Drew? Bringing in 5 new members. Thank you, Drew. Snoopy's here. Harley Girl, William L, Misfit News, and Fabian all coming in courtesy of Drew, the man. Welcome aboard. Glocky McGlock is here, says, hey, Rob, now would be a good time to remind everyone that Jack Smith was flown in from a country he lived in, like in the Netherlands, to come to America to prosecute Biden's political rival. They probably even paid for his house with your tax dollars. Here's our newest flag, the Banana Republic flag. It's a great point. Yeah, and he's not even a U.S. attorney. Here's President Biden. He introduces the new flag, the Divided Republic States of America. Glocky says there are only 2 options for the Republicans' cowardice doing lawfare. They are either A, total cowards. It's good. I like that one. B, have incompetent lawyers. Or C, complete grifters who don't care about their voters, or it's a combination of the 3. I'm going to choose option D, which is A and C. You know those questions? Total cowards and total grifters as well. And they don't care about their voters at all. So good to see you, Glocky. I think you nailed it. Good multiple choice there. Says it was supposed to be 3 options, but apparently autocorrect thought I was full of crap. A, B, C. Okay, 3 options. Yeah, there are only 3 options. There you go. We picked it up, Glocky. Thanks for that. I say it's option D. Answers A and C. We got this from Waldo bringing in 5 new members. Thank you for bringing in the members, Waldo. Natasha M. Mark L's coming in the house. Frankie E. Coco Hall's here. And Night Watchman is coming in, courtesy of Waldo, our newest members. Thank you, Waldo. Jeff is also our latest supporter. Welcome aboard, Jeff. We got a lot of members coming in. Tony Hay Munkets is bringing in some more members. Chris in here. Old Man JM. Belladonna High. Kurt S is here. And One Wolf coming in thanks to Tony Hay Munkets in the House. We got some new members, man. I'm loving it. And Mimi's here. Mimi McG says, thank you, Rob, for all your great work going over and explaining what to mostly me, is very confusing legal filings. They're confused. Yeah, there's a lot going on, and it is hard to kind of keep track of all the things. We've got 4 criminal prosecutions, plus the appeals, plus the ballot removal stuff. I mean, there's a lot going on. So it's easy to get a little turned around on it. Says, but Happy New Year, Mimi. Happy New Year to you. And says Trump 2024, which of course we endorse. Thank you, Mimi, for that. Sergeant Willie has been a membo for 7 months in the House. Thank you, Sergeant Willie. 2 months. We got that baby coming out. We got this old guy talking about this Colorado attorney dude. Says this guy should cease practicing law immediately. No matter how long he practices, he'll never get it right. This old guy, he was just basically regurgitating talking points. There wasn't much else to unpack there. But you're right. He's doing his job. He's doing his job. The talking points, like that is his job as a Democrat lawyer, I guess. Knox is here, says, okay, if Trump had just moved to Florida, called on all the South to rise up again, purchased arms from Mexico, while Melania sewed a new flag, maybe, a 4-hour protest is not an insurrection. And instructions to peacefully protest is not a call for secession. From Knox Bierman. Good to see you, Knox. While Melania, yeah, maybe. Okay, I see what you're saying. Like if Trump was Jefferson Davis orchestrating Civil War 3.0, then maybe it would apply. Daniel Henry's here. Says, what's up? What's up, Daniel? Thank you for this nice one. Says, the final clause from the Colorado Supreme Court says Section 3 requires the president to, quote, commission all the officers of the United States without exception. Since he does not commission himself, he cannot be an officer of the United States. QED. From Daniel Henry. Which is what? Quergo Epsom something? Yeah. Says commission. So we saw that in the brief today too, right? That was the same argument. Trump saying, look, I'm the president. Like the president is the root source. It's like zero. Everything starts from that. That position has the power to do all the things the Constitution articulates. So the president cannot appoint himself. It's like dividing by zero. It logically just doesn't work. But Colorado just says, well, if he can do that, then anybody's above the law. And you go, well, yeah, the president kind of is above the law, like literally. Sorry to tell you that. But that's how the Constitution works. Thank you, Daniel. Nice comment. Nice dono. Jeegum says, do you think that they believe what they say, or do you think they know it's wrong, but feel it's justified because they have TDS? Definitely the latter. So for example, like if Trump was in charge and doing any of this stuff, they would be screaming, right? About like us, they would be agreeing with us. Like this is the end of the world. But I would say the same thing. Like if the Republicans were throwing Joe Biden off the ballot, I'd say this is not good. This is bad news. Now I think that it's just politics. Like now we just have to do it. If they're going to do it, we got to do it. I regret that our country has gotten here. I think they know that it's bad. And I think they know it's bad because if it was happening to them, they would be, they'd be upset about it. Whereas my position is I think it's just bad across the board. So I think it's justified. I think they know it's bad, but they don't care. It's TDS. V says, okay, so let me ask this logical question. If some part of the population knows someone is criminal and wants to vote for said criminal, what percentage of the population has to desire such a thing before they should be allowed to vote for a criminal? Should be allowed. At what percentage does it become the will of the people? At what percentage does a person simply accept they live in a land of criminals? Or conversely, V, I would say that the people say it is not criminal, right? It's like jury nullification. The people can nullify the law. If the executive branch, through the DOJ, Merrick Garland, Biden, if they want to prosecute somebody, we can veto that. We can say, no, we don't think that's appropriate. That's the ultimate check. The people have the ultimate check. That's democracy, not the opposite. Knox says, okay, Jack Smith is like one of those people who build relationships around you. Keeps your pick, tells his fam about you when you've only had like one date or something. Yeah, so like first date, he's like, hey, my girlfriend and I just had a serious talk. I'm like, you have a girlfriend already? You're weird, man. Does she know that? All right. 1R5 says in 1860, Abe Lincoln was off 10 ballots in southern states. So Trump is not the first Republican to get bumped by the Dems. Yeah. And where'd that go? That didn't turn out so well for America and 600,000 dead Americans. So it resulted in the Civil War, obviously. We've got Chubby Stubby says the contempt allegations against the deranged thug are just more evidence that he is not a legitimate choice for special counsel, since he clearly doesn't understand or respect the laws or the legal system of this country. Does not respect the laws or the legal systems of this country. That's probably why they brought him in, and he's not appointed or confirmed by the Senate, because he can just do his bidding as he wants. We got Juan is here. What's up, Juan? Says, doesn't Section 1 of the 14th Amendment defeat the argument of Section 3 being self-executing? Yes, according to the Trump side, but according to the government, according to the Colorado and the courts, they say no. They say Section 1 is separate. So basically you have to consider the separate sections independently of one another. And Section 3 is not contingent upon Section 1. Ray K says these people played in the shadows before. They're all out now. What happens if Trump actually wins? Are they going to say the good game? Are they going to say good game? Nice job? No. They're not going to do it, which is concerning, right? Like, in other words, when they say things like he's going to wreck the whole country and wreck American democracy, how can they let him do, like if they believe that, if the president believes if Trump wins, the country's over, like, just take that at face value. Take that as a not political statement. If Trump wins, the country's over. That's a threat to national security. So what is the intelligence community going to do to stop that? What is Biden going to orchestrate as the governor of these agencies? What is he going to allow to stop that? It's their words, not ours. It's scary. Dolphin Fan is the man saying, bringing in Gundam, bringing in Sassy Tech, Rebecca J, Jill Kraft, Stephen E's in the house, courtesy of Dolphin Fan is the man in the house. We got Golden Gaming, 9 months, baby. Woo! Woo! We got a new baby in the house. Golden Gaming has one here for us. 9 months. Happy 2024 watchers. Make it a great one. Good to see you, Golden Gaming. Thanks for being a member for 9 months. We have our newest addition to the Watcher fam in the house, Golden Gaming. And Dolphin Fan, we got Mountain Goddess is here. Says, can Nancy Pelosi be charged with threats against Trump when she said on video that she wants to punch him and go to jail and she would be happy? Probably not. You know, threats and harassments. I don't think it would actually rise to that. Now, if Trump said that, yeah. Well, I mean, look, if we're going to apply the same standards equally, yeah, I think she should be charged. In fact, I think she'd probably be arrested and thrown in the gulags in D.C. for threatening an insurrection. Now, of course, you know, it's just like body talk kind of a thing. I don't know that any prosecutor would actually bring charges, but we'll see. Maybe the new American will be new America under might makes right. We'll change this. We'll see. Fred Pedamonte says, have to say that Lauro and Blanche's motions are great. They are good, Fred. That was a real fun one to read through. And we had some good motions today. We had some spicy motions today. A lot of fun. Ray K says, for those who are gym phobic, I'm offering a pork chop challenge on my channel, sponsored by Field of Meats. Oh, man. Can we cancel our challenge and come over to your challenge, Ray K? Pork chops and Field of Meats? Oh, gosh. How much bacon is it? Like bacon every day? Bacon every single day? That doesn't... Well, I'll be dead in 31 days. We'll have a heart attack. All right. Thanks for that, Ray K. Anyways, good to see you. Have fun with your challenge. This old guy says, Biden conferring with scholars, Claudine Gay, Liz McGill, and Sally Kornbluth. Joe Biden is calling his plagiarist buddies. He's out there saying, hey, can you help me plagiarize some stuff about the insurrection? I'm like, sure, we'd love to. That's from this old guy. Nivek is here. And locals, we're going to fire up another stream here in a quick second, so just hang tight because this one is going to expire. We are time limited on locals, and so we're going to redo another stream here in a quick second. So hang tight. Nivek is here. Says armed assets were used in this setup, making this an insurrection by the Democrats, preventing debates from state objections. The VP does have authority to allow alternate electors as a result of debates. Totally agree with this. Like Mike Pence had the option to get into it. And the reason we know that is because they changed the rules after the fact. They actually tightened up that limitation so that this would not happen again. And Trump, in my opinion, is allowed to exercise his authority to the fullest extent of the law. So is Mike Pence. And he did that. And they had a meltdown over that, obviously. Good to see you, Nivek. Thanks for that one. Hey, TJ Elton says, thank you, sir, for helping me understand what our country is putting President Trump through. You are a national treasure. Keep up the good work. Well, TJ, such a nice comment, man. Thank you for saying that. I appreciate you being here because I agree this is going to be important. This is historic stuff. I mean, the reason we're focused so hard on this, I think this is a fissure point for the country, and it's going to be historic for all time. So we'll be here continuing to cover it. Now, let me get our locals friends back online, and let's see how I can do this. So we're going to go live over here. That stream just ended. Locals is back over here. We're going to start the stream over here. Locals, the audio might be a little hot because we're going in, we're connecting the tubes a little bit differently, but I'll lower it here in a second as soon as we're done. TJ Elton is in the house. Thank you for that one. I appreciate you being here, my friend. The show would not be possible, TJ, without you being here. So thanks for being here. We've got another one from Air Force Vet says, YouTube banned me from sending you money. Working on it. What? YouTube did that? Probably some feds out there. Air Force Vet, been a member. Air Force has been a major contributor to helping us solve the national debt here. And so hopefully it gets fixed there, Air Force Vet. We got a big debt to pay. We got another one from Niels, says Epps is saying peacefully is coded language. Yeah, that's a great point. Sounds very insurrectionary to me. I think so too. We've got this one from Spuds. Says Texas Governor Abbott releases a statement after New York City mayor states the city is going to sue the bus companies who are transporting migrants from Texas. Wild. So Adams threatened to charge them with misdemeanors. Rivka says, I think the Proud Boys lawyers and many others should write amicus briefs for the prosecution outlining what their clients got for lesser behavior. That's a great point. I got to imagine a bunch of defense attorneys are outraged by this sentencing recommendation. Like, what? What? Pinochet Helicopter Tours says average citizens should understand how compartmentalization, how plausible deniability and insurgency and counterinsurgency work. Never in writing, always in cash. Yeah. Like, I think that we think Ray Epps is going to have an FBI badge or something. Like, no, nobody thinks that. Okay, but we all have questions about the double standards that clearly exist. CF Rob says, hey, the Secretary of State in Arizona stole the election from Kari Lake. Somebody did, because the election was totally rigged on that day. I was here. Tasadaka says, how many J6ers sat in jail waiting for trial for over 2 years without bail and being tortured in solitary confinement? A lot more than Ray Epps ever did, that's for sure. We got B-Man says, it would be great if the judge turned around and gave him 10 years. I reject your plea. You're just like the other J6ers, but the judge is, the judge probably knows about it too. There's probably, off the record conversations. The judge knows what's going on. Hey, Crash is here, says that, Rob, that sound that you hear so faintly tonight, well, those are the barks of the hounds straining at the leash. If SCOTUS agrees with Trump in the Colorado case, the left will go absolutely crazy. The spring and summer will be unbearable. Get ready. I think you're right, Crash. They're going to blame the Supreme Court and then use any Supreme Court decision to delegitimize Trump again and the Supreme Court simultaneously. It is going to be wild. There's no doubt. 3D Slug says World War III around election time and border open to allow more fighting age people in. That's the Democrat plan. So there's not going to be an election, right? They might say that Trump, you know what I was thinking about? And I'm sure somebody else has said this, but we talk a lot about them taking Trump out, about them, a lot of people have been hinting about that. saying that Trump is going to be the one that they will not let in. But my thought would be, what if there's something happens the other direction? Okay, so, Joe Biden's in charge, something bad happens to him. Again, I'm not wishing for it or anything, but I'm just, we talked about this morning on our members only stream about him having a difficult time walking up a flight of stairs. Like he hardly could do it, even the short steps. So if anything happens to him, and if something aggressive happens to him, what happens if they blame it on Trump, right? They say, okay, so Trump is the leader. He orchestrated this attack on Joe. So it's like a twofer. So Joe's no longer in play and Trump gets blamed for this, right? So it's a double win. Then they say Trump now no longer can be allowed, and they get a new candidate as well. Something like that, I think, is also a serious concern. So I'm trying to game this out in our head. How do they allow this to go on? They're going to blame the Supreme Court when the Supreme Court puts a limitation on their deal. And so something else, might come down the pike, but it sounds like a good a solution as anything. We're waiting for it. We've got this one from Sergeant Willie. Says, I said Alina Abba was on Patrick Bet David. I haven't watched it yet, but maybe I will. Patrick has a good show. It's a good show. Hey, Flash says, Rob, given Jack Smith's tenure as the chief prosecutor for the Kosovo Specialist Chambers in The Hague, a role that situated him outside the United States, I'm curious about your perspective on the necessity of his registration under FARA, foreign agents. This act typically applies to those representing foreign interests in a political or quasi-political capacity. How do you view Smith's position in this context? So I think it would be FARA would be for anything that's like outside of the government. Like if you're an agent of the government and if he's a representative of the government, I would think that he would be, exempted from FARA reporting. It's more because as long as he's operating within the confines of the government. So I just think that they're two kind of separate things. So it doesn't necessarily apply to him. Now, if he's acting outside of that scope, like for example, Flash, there was another story that we didn't talk about here because I wasn't sure where it was sourced from, but there was another story from, I think it was an ex somebody who reported to somebody that Jack Smith was acting as a foreign agent. Okay. And he actually was trying to blow the whistle on it. But the reason we didn't cover it here, because it was like a little bit too far removed. I read it and I was like, where did this whistleblower get this report from? He said he got it from some other guy who got it from some other guy. I was like, okay, a little bit too far removed. But if that's how he was acting, then maybe something like that would be applicable. Daniel Henry's here, says, Rob, I like you. Oh, says, Robert, I like you, comma in there, have a crush on FreeStateWill, but I'm confident my feelings on the matter are different than yours. Winky face. So probably, I would agree with that, Daniel. I would agree with that. I think that's probably true. I have a crush on his legal writing and the fact that he obliterates ugly prosecutors. Your rationale might be different. But FreeStateWill is the man regardless. So shout out to FreeStateWill. We got this one from Knox. Says the courts are crazy party is over. And I will rewatch this tonight. Oh, okay. So Knox was in court today. She's a defense attorney out in Texas. Shout out to defense attorneys in Texas and Knox. Says the courts are crazy party is over. I'm going to rewatch tonight. Thank you, Robert, for keeping me up to date on all of this. Well, Knox, thanks for being out there fighting the good fight, representing the presumption of innocence out there in the court of law. We need good lawyers on our team. And so we're grateful for Knox. We got Pinochet says January 2025 is going to be even scarier. That's my Army vet intuition. Well, that's some good intuition there. Thank you for your service, sir. And we appreciate that. I agree that if Trump wins, January 2025 is going to be lit. My goodness, no doubt. Curtis Bartle, 18 months. That's 2 babies. Oh my goodness. Curtis Bartle, 18 months, my man. Thanks. That is a long time. 18 months. Thanks for being a member for so long. MAGA or bust 2024. Thanks, Rob. Thanks, Curtis, man. Thanks for saying that. And for being a member for 18 months. 2 full babies today. Whew. Amazing. Okay, so Curtis, thank you for that. We're going to hop over to the X platform before we jump over to our locals, members only after party at watchingthewatchers.locals.com. Let's see who is joining us in the house over here today. And we've got 22 viewers on X. Amazing. Let's see who is joining us on the day. Amazing. Okay, so Maynard says FreeStateWill sent a letter to him, sent me a copy pocket constitution. He prevails in this case. Thank you for supporting the Constitution and the J6 defendants. Please pray for America. May God's love be with you always. From Will. What a guy. Incredible. So see that, man? He's a good dude. Okay, so FreeStateWill sent me a copy of the Pocket Constitution. Amazing. Make sure you're following him, my friends. He could use your support. Hey, George is shouting us out. Feline Fun says, illegitimate jacks, congressional submissions are due today. Let's see if he defies Congress the same way he defies court orders. Maybe we can add a subpoena in addition to the contempt charges, see if Chutkan holds him accountable. Goofy for Jesus says J6 was a setup, period. Hopefully some IG, etc. somewhere will figure that out. P.S. Watch the vigil tonight at D.C. Oh, there'll be a vigil tonight on the D.C. So Freedom Express Media is doing vigils on YouTube. Fred Pedamonte says that Epps BS reminded me of Comey stating all the illegal things Clinton did, but then said, but no reasonable prosecutor or whatever bring charges. Yeah. V says, you know, the only way these people could legitimately say that Trump saying peacefully is a call for violence would be for them to admit the large amounts of violence in the previous summer, thus a fiery, but mostly peaceful protest. This one came out from Fred. Did you guys see this from Steve Friend? No, I have not. But Steve Friend is a former FBI agent who's also doing good work. V says, so the Epps said, don't beat up the cops, and then he helped beat up the cops. Yeah, that's right. That's exactly right. And so he's also Vindictive. He's the victim of a conspiracy. Danny says, what happens to informants in jail? What happens to FBI informants in jail? They don't let them go to jail. V says, even though I've got no use for two-party paradigms, I do think it's pretty funny to say that the Democrats already lost one civil war in American history. Try it again, Democrats, idiots. All right, so that's pretty funny. Our friends on X, if you want to follow us over there, great way to connect with other people who are on the X platform. You can follow us at Rob Govea, ESQ, on the X platform. And of course, follow the other watchers who are out there in the wild. But that, my friends, is it for us on the day. We are going over to watchingthewatchers.locals.com for our members only after party. We'd love to see you there. We had this one come in from Pinochet. Says, I think of J6 as our Reichstag fire, which is what Adolf launched when he was taking over his country. And he also had to say that he was doing it to save the country, right? To save democracy. It was all the same crap. Orchestrated an attack, blamed the other side, then exploits that to gain total power over the country. Sound familiar? Yeah, definitely does. Okay, so Pinochet, thank you for that. We are going over to watchingthewatchers.locals.com. We would love it if you joined us. We have an awesome community. We have a lot of fun. We do members only streams in the mornings, 5 days a week, plus a Saturday stream. And we love to have you here. So come and join us, watchingthewatchers.locals.com. YouTube members, you can join us on the after parties. Navigate over to the community tab section on YouTube, scroll down, grab the Telegram link. We'll see you on the Telegram app. That's where we'll be. Before we wrap it up, reminders, we've got robertgovea.com is our website. We've got all of the PDFs are there. We have our daily newsletter that's there. I would love it if you signed up for that so that when those emails come in, you forwarded it to everyone in your whole life. Just forward all every day. Just send it all to everybody. Say, all right, we're saving America here. Enjoy the forward. And then that's good news. So robertgovea.com is a great way to do that. And they're not going to be mad at you anyways. Like, they like you. They love you. They're not going to be mad at you. Probably. We also have our fitness challenge, which is on right now. We're having some fun with this. Watcherlodge.com. You can go there, sign up, 31 days commitment. We're holding open the invites up until January 5th, which is tomorrow. So come and join us. We have a lot of cool stuff happening there. Here's what it looks like behind the scenes. I have already posted my day 4 update. You can see that right here. Day 4 today, we did some shoulders, we did some abs, we did some cardio. I posted the Arnold. Arnold just dropped a nice fitness list there, so you can go check that one out. We talked about the best apps for fitness yesterday when I was doing, what did I do yesterday? Don't even remember. But that was my update. We got a bunch of people dropping their comments in here and getting fit, man. So come and join us. We're going to be giving away one cash prize for someone who is participating. scholarships to the lodge, because we've got a lot of other fun stuff coming down the pike. Fitness is not what this is all about. It's about sovereignty. It's about self-development. It's about going deeper with our community. We just happen to be starting with fitness. And so we're going to be giving away some scholarships as well for the full lodge when all of it launches in full. And so come check it out, watcherlodge.com. It's about sovereignty. It's about self-development, and we need to be fit. We need to outlift the opposition, and we're going to be doing that. watcherlodge.com. So come join up. We also are going over to watchingthewatchers.locals.com right now. We'll see you there. Mods who mod down the fort for us and keep things nice and orderly. We want to thank our friends. Vienticus Prime in the house. K-Bean, Just Cause, Playin' Hooky, Ronnie Cole, our friend Zulu, Beyond Geo, Zach Nichols, John Allen, Janek, Dog Digger, and Donut Mind Me. All in the house, modding the fort down for us. We're grateful for you. Geegum Geegum, our friend Nathan N810, and Sleepy Dog Lee, memeing the place out, keeping things nice and beautiful. But that, my friends, is it for us on the day. We're going to be back here tomorrow, Friday, to get into it all again. And we hope to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with a hope of finding justice. Make it a beautiful night, my friends. Sleep very well. See you right back here tomorrow. Bye-bye.